Court officer, sir. Court officer, sir.
Seven 30 sir. ಇದು ಒಂದು ಪ್ರಶ್ನೆ ಆಯ್ತು ಅಲ್ಲ ಇದು ಎಷ್ಟೊತ್ತು ಬರುತ್ತೆ ಬಂದ ಕೊಡಿ.
ಇದು DML ಇಲ್ಲ ಸರ್, ಇದು 24 ಮ್ಯಾಟ್ರ್ TM RES ಸರ್ ಇಲ್ಲ ಸರ್. ಓಕೆ ಸಾಹೇಬ್ರಿಗೆ ಹೇಳಿ ಕೊಡ್ಬೇಕಾ ಸರ್? ಸಾಹೇಬ್ರೆ ಹೌದು.
ಸರ್ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್
ಸರ್ ಸರ್ ಒಂದ್ಸಲಿ ಪಾಸ್ ಓವರ್ ಆದ್ರೆ 2:30
ಡಿಪೆಂಡ್ಸ್.
ಹೌದಾ? ಅಲ್ಲ 1:30 ಬಿಫೋರ್ ಕರೆಯೋ ಸಾಧ್ಯತೆ ಇದೆಯಾ? ಯಾಕಂದ್ರೆ ಇದು ಸೆಟಲ್ಮೆಂಟ್ ರಿಪೋರ್ಟ್ ಮಾಡ್ಬೇಕಾಗಿತ್ತು. ಅವರು ಪಂಜಾಬ್ ಆಪೋಸಿಟ್ ಪಾರ್ಟಿ ಲಾ ಆಫೀಸರ್ ಬರ್ಬೇಕು, ಅದಕ್ಕೇನೆ.
ಹೇಳಿ ನೋಡಿ, ನೋಡೋಣ ಹಿಂಗ್ ಬರುತ್ತೆ, ನೋಡೋಣ ಸೀದೆ ಮಾಡಿ.
ಓಕೆ ಸರ್.
ಸರ್ ಕವರ್ಡ್ ಮ್ಯಾಟ್ರು
ಬಂದ್ಮೇಲೆ ಕೊಡಿ.
11:30ಗೆ BWSSP ಇಲ್ಲಿ ಅಲ್ಲ EM ಬಂದ್ಮೇಲೆ ಬನ್ನಿ 11.
ಸರ್ ಡೇಟ್ ಮ್ಯಾಟ್ರ್ ಇತ್ತು ಬಂದಿಲ್ಲ ಇವತ್ತು.
ಯಾವ್ದು?
CRP
ಇತ್ತಾ?
ಇತ್ತು ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಇಲ್ಲ. ಪರವಾಗಿಲ್ಲ, ಡೇಟ್ ಕೊಡ್ಲಿ ಪರವಾಗಿಲ್ಲ. ಪರವಾಗಿಲ್ಲ, ನಮ್ಗೆ ಡೇಟ್ ಲಾಂಗ್ ಡೇಟ್ ಹೋದ್ರು ಪರವಾಗಿಲ್ಲ. ನಮ್ಗೆ ಸಿಟ್ಟಿಂಗ್ ಇಲ್ಲ, ಅದು ಡೇಟ್ ಮ್ಯಾಟ್ರ್ ಬಂದು ತೋರಿಸಿ. ಸರ್ ಇಲ್ಲಿ ನೋಡ್ಕೊಂಬಿಡಿ ಒಂದು ನಿಮಿಷ.
ಏನ್ ಹೇಳಿ ಸರ್ ನೀವು?
ಅದು CRP 106 ಇತ್ತು, ಲಿಸ್ಟ್ ಆಗಿಲ್ಲ. ಅದೇನ್ ಮಾಡೋದು ಸರ್ ಅಂತ.
ಕೊಡಿ, ನಂಬರ್ ಕೊಡಿ.
ನಾಳೆನೇ ಪರವಾಗಿಲ್ಲ, ಸ್ವಲ್ಪ ಲಾಂಗ್ ಡೇಟ್ ಹೋದ್ರು ಪರವಾಗಿಲ್ಲ ನಮ್ಗೆ ಅಂತ. ಓಕೆ, ಲಿಸ್ಟ್ ಇಲ್ಲಾದ್ರೆ ಬರಲ್ಲ ಅಲ್ವಾ ಸರ್? ಸರ್ ಮೆಮೋ
ಬಂದ್ಮೇಲೆ ಕೊಡಿ.
ಸರ್ ಒಂದು ವೆಕೇಟಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದೆ, ತಗೋತೀರಾ?
ಬಂದ್ಮೇಲೆ ಕೊಡಿ ಸರ್.
ಬಂದ್ಮೇಲೆ ಸಬ್ಮಿಟ್
ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರು ಸಬ್ಮಿಷನ್ ಮಾಡ್ಬೇಕಾ?
ಇಲ್ಲ.
ತೊಗೊಳ್ಳಿ ಸರ್, ಇದು ಫ್ರೆಶ್ ಮ್ಯಾಟ್ರು.
ಸಬ್ಮಿಷನ್ ಮಾಡ್ಬೇಕಾ ಕೊಟ್ಬಿಡೋದು ಸಿಟ್ಟಿಂಗ್ 11:30ಗೆ ಬರ್ತಾರಿಂಗ್ ಇದೆ ಮೂವತ್ತೆಲ್ಲ ಸಾವಿರ ಬಂದು ಕೊಡಿ ಇಲ್ಲ ಬರ್ತಾ ಎಂಡ್ ಆಫ್ ದಿ ಲಿಸ್ಟ್ ಕೇಳ್ಬೇಕು ಸಾಹೇಬ್ರಿಗೆ ಹೇಳ್ಬೇಕು ಸರ್ ಮೆಮೋಸ್ ಎಲ್ಲ ಕೊಟ್ಬಿಡಿ ಸರ್ ಎಲ್ಲ ಮೆಮೋಸ್ ಫ್ರೆಶ್ ಸರ್ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಪೆಂಡಿಂಗ್ ಎರಡು ಫ್ರೆಶ್ ಈಸ್ ಕಮಿಂಗ್ ಅಟ್ 11:30 ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಮಾತ್ರ ಬರುತ್ತೆ ಬೇರೆ ಬರೋದಿಲ್ಲ ಮೆಮೋಸ್ ಕೊಟ್ಬಿಡಿ ಎರಡು ಫ್ರೆಶ್ ಸರ್ ಅದು ಓಲ್ಡ್ ಮ್ಯಾಟರ್ ಸಬ್ಮಿಷನ್ ಮಾಡ್ಬೇಕಾ ಓಲ್ಡ್ ಮ್ಯಾಟರ್ ಸಬ್ಮಿಷನ್ ಮಾಡ್ಬೇಕಾ ಓಲ್ಡ್ ಮ್ಯಾಟರ್ ಸಬ್ಮಿಷನ್ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಕೊಡಕ್ಕೆ ಹೇಳಿದ್ದಾರೆ ಅಷ್ಟೇ ಹೌದಾ ಓಲ್ಡ್ ಮ್ಯಾಟರ್ ಮತ್ತೆ ಮೆಮೋ ಏನ್ ಕತೆ ಇದೆ
ಸರ್ ಫ್ರೆಶ್ 421 ಇದೆ ನಾಳೆ ಕೊಡ್ತೀರಾ ಅಲ್ಲಲ್ಲ
ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ ಸಬ್ಮಿಷನ್ ಮಾಡ್ತಾರೆ ಫ್ರೆಶ್ ಮಾಡ್ರೆ ಕೊಟ್ಬಿಡ್ರಿ
ಡೇಟ್ ಯಾವಾಗ ಕೊಡ್ತೀರಾ ಡೇಟು ನಾಳೆ ಕೊಡ್ತೀನಿ ನೆಕ್ಸ್ಟ್ ಮ್ಯಾಚ್
ಸರ್
ಸರ್ 11:30ಗ ಸರ್ 11.
ಸರ್
ಹೇಳಿ ಸರ್.
ಸಾಹೇಬ್ರು 1 hour ಬಿಟ್ಟು ಬರ್ತಾರೆ ಅಂತ ನನಗೆ. ಓಕೆ, ಐ ವಿಲ್ ಬಿ ವೇಟಿಂಗ್.
ಸ್ಟ್ರೀಮ್ ಆಫ್ ಮಾಡಿದಾರದಲ್ಲ, ಆಫ್ ಮಾಡಿದಾರೆ, ವಿಡಿಯೋ ಆಫ್ ಮಾಡಿರೋದಲ್ವಾ, ಆಡಿಯೋ 11
Fresh matters you can please give. Fresh matters you can please give. Only fresh matters you can please give. Memos.
I have a pending matter.
Pending matter, you will have to file an application
Honorable
citing
Justice,
the reason for early hearing. It will come up for hearing on IA. We will consider.
Honorable Justice,
If you have,
Here is a
if you have-
suffering.
if you have already filed an application, you can give the memo. Please give.
Honorable Justice, here is,
Admission,
Huh?
18 matter. ERP, 2018 matter.
Honorable Justice, here is a suffering of an old ailing, cancer ailing woman for so many years.
Yes.
Kindly give me an
If it
opportunity.
is a fresh matter, you please give it. Otherwise, you file an application for early hearing.
Yes, the application you have accepted and even the desk clerk signing 3 times, 3 attempts have made.
Applications are filed.
Yes,
Please give memo.
even 3 attempts, the application goes to somewhere. I have a lot of story about your bench clerk. Kindly accept this.
Please give the memo if you want to give. Otherwise, you keep it with you.
Yes, I am trying to,
Please
See
give the
that
memo.
memo
Now, if you
reaching
want to
this
give it, you
court.
please give. Otherwise, don't give. Yes.
My lord, pending
Ins-
matter, my lord. I have filed a
we have come for justice, your honor.
ಕೊಡ್ರಿ ಅಂತ ಹೇಳ್ತಾ ಇದೀನಲ್ಲ, please give it.
ಸರ್ ದಯವಿಟ್ಟು 3 ಅಟೆಂಪ್ಟ್ ಆಗಿದೆ ಸರ್, ಕೊಟ್ಟಿರ ತಗೊಳ್ತಾ ಇಲ್ಲ. ದಯವಿಟ್ಟು ಅದನ್ನ ಒಂದು ಡೆಫಿನೆಟ್ ಡೈರೆಕ್ಷನ್ಸ್ ಕೊಡಿ.
Tomorrow, please give it.
Kindly give the definite direction. I can wait.
Please give the memo. Yes.
ಅವ್ರು ತೋರಿಸಿಪ್ಪ ಅವ್ರಿಗೆ.
Huh?
Application for vacating interim orders can be filed.
Wait, sir. Kindly do.
ಕೊಡಿ. Yes.
I have to submit. This has been happening.
withdrawal ಅದಕ್ಕೆ.
ಕೊಡಿ. Yes.
Matters, my lord, are covered by the judgment of this honorable court, 2018 matters CRP.
So if there are old matters, you file an application for early hearing, we will consider. Yes.
Sir, Honorable Justice, I'm filing it. Kindly give a date.
Please call out.
This number,
Yes.
number 1.
You are not listening.
ಕೊಡ್ರಿ ಅಂತ ಹೇಳ್ತಾ ಇದೀನಿ. You want to keep it with you, you keep it.
ಇಲ್ಲ ಸರ್,
ಕೊಡಿ
ಕೊಡ್ತೀನಿ ಸರ್,
ಮತ್ತೆ.
ಒಂದು ಡೇಟ್
Please give it.
ಡೆಫಿನೆಟ್ಲಿ ಕೊಡಿ ಸರ್.
Yes, ಕೊಡಿ.
My lord,
Yes.
my lord,
ದಯವಿಟ್ಟು.
my lord,
Yes, please call out.
my lord, my lord, I'm party.
Madam, what is this? If there is any fresh matter, you please give. Otherwise, I have said what has to be done. Huh? Then what is the urgency?
Association matters are listed.
Ah.
Listed matters, they're seeking for 33% reservation. It's listed at 31. I am requesting.
You
that
can
we
make
can-
submissions. The petitions have already been filed. It cannot be called today along with that, madam. We will see. Yes,
My lord,
yes.
I'm party in person, my lord. This matter is listed on 5th, 12th, 2024. To be listed on after vacation, my lord. No date has been given. So one,
ಬರೋದಿಲ್ಲ. You file an application. Yes. Huh? No. Yes, please call out.
First matter, serial number 1, Venkatesh S. R. Bhatti.
The petitioner, but in a case of demand and acceptance of bribe, not the minimum punishment is either compulsory retirement or not removal from service. And a recommendation not is rejected and punishment of withholding of increment is.
Henry, I can't understand why
But-
Lokayukta is filing these kind of
I- I
petitions.
Not if it is, not if the order is illegal, not
Learned AGA takes notice for respond number 1. Issue notice to respond number 2.
great.
Learned counsel for petitioner is direct to serve copies of the petition along with annexures from the learned AGA. Yes.
I appear for the petitioner, my lord. My lord, a week's time may be granted, my lord. May be taken on next Friday, my lord.
My lords, one submission. There are about 7 matters pertaining to the same relief, my lords, by different advocates. I will give a list, my lords, to the court officer later. The same may be posted along with all those. Matters. About 15 days' time may be granted, my lords. I will file objections.
No interim relief is given.
No, my lords, this is about surrogacy.
Surrogacy.
Surrogacy, they are seeking a direction from this honorable court to
Then-
undergo surrogacy procedure.
Different parties.
This is one party, my lords. There are different parties. The case numbers I'll provide. my lords.
You are appearing on behalf of
The government, my lords, Union,
Union of India.
only first respondent, please, my lords,
Union of India.
please.
Your name is shown.
Yes, my lords,
Your file wakalat.
please.
What about response number 2 and 3?
State will take, my lords.
State, huh?
Howd.
Huh?
Learned AGA takes notice for response number 2 and 3.
Please, my lord.
Learned counsel for petitioners is directed to serve copies of the writ petition along with annexures on learned AGA. Full stop. Learned counsel for respondent number 1 seeks for some time to file statement of objection.
Please.
Full stop. She further submits that similar petitions are also pending consideration before this court.
Please.
They have all been clubbed together.
Yes, my lords, though not clubbed, but I will give, provide the list, my lords, it may be clubbed.
And therefore, it is prayed that this matter also may be called along with those matters.
Please, my lords.
Next para, list this matter along with, you give one number, the first case number
Yes, my lords.
will be linked.
Good.
Yes.
Serial number 3,
Grateful, my lord.
Rajendra Desai.
For petitioner, my lords. My lords, in this case, my lords, the petitioner is a partnership, my lords. And the petitioner holds a current account in the respondent bank, my lords, that is Bank of Baroda, my lords. On 8/2/2021, my lords, there was a 12 unauthorized transaction from my account, my lords, from the current account. That was informed on the same day, my lords, to the bank.
You know,
That was informed to the bank, my lords.
what was informed?
That unauthorized transactions were informed to the bank, my lords. And I have produced the SMS alerts, my lords, which I have received as a at next year, my lords.
Learned AGA takes notice for respondent number 2. Issue notice to response number 1 and 3.
Please.
Learned counsel for petitioner is directed to serve a copy of the writ petition along with annexures on learned AGA.
4, Rajeshwara PN.
Here for the petition. And in this petition, I'm seeking writ of mandamus, well, it's directing the bank to permit me to manage the account, well, I'm the sole trustee of the trust, well, there were objections, so they have deactivated my account, well, I'm finding it difficult to manage the day-to-day affairs of the trust.
To operate, to permit the petitioner to operate.
To operate the bank account, well, they have blocked the account, well, bank has blocked the account.
Why?
It's, there are some objections with respect to the management of the trust. I'll take notice on the panel of it.
Issue notice to the respondent.
I'll take notice, my lord.
Canara Bank.
Bank.
Huh?
Yes, my lord.
Learned counsel, Shri Shamant Naik,
Yes, my
who is present in the court, takes notice for the respondent bank. Learned counsel for petitioner is directed to serve copies of the writ petition along with annexures on the learned counsel for the respondent.
It's my request for a date. My request for a date.
Yes.
5,
Wait.
Sachin BS.
Lords, I appeared for the petitioner, my lords. I'm challenging a notice, my lords, issued by NHA. Lords, the notice, my lords, says that I am in unauthorized occupation, my lords, of the highway land, my lords. There is no, my lords, survey, no report, my lords, nothing. There is not even time, my lords, to given for me to reply to this notice, my lords. They say within 3 days of this notice, please give me a reply. Lords, there must be some reasonable time, my lords, to at least give a show to reply to a notice, my lords.
Anyway, that was given on 19th
Please, my
of
lords.
September.
My lords, they are now precipitating the matter, my lords. That is why we have moved the
What have
matter.
you done after receiving the notice?
My lords, we have done nothing, my lords, because because there is no unauthorized occupation itself, my lords.
So you are at least obliged to give a reply,
Please,
giving the documents of title.
Please, my lords.
You have not done that.
My lords, it may be treated as show cause notice, my lords. I will 1 week time, my lords, with the including reports. I'll give it to the NHI.
What do you say?
Appearing for the respondent, my lord. They may issue the reply, the writ petition may be disposed of, and accordingly we'll reply. My lord, just one submission in their own facts of the case, my lord. They've addressed to the very fact that dated 18/12.
Take a notice.
Notice has been issued, my lord. I have taken notice
You
for
have taken
response.
notice.
I have entered appearance as well.
The petitioner is aggrieved of the impugned notice at annexure A dated 19th of September 2024, issued by the respondent, National Highways Authority of India. Full stop. Learned counsel for the petitioner submits that a plain reading of the notice clearly shows that action is sought to be initiated by the respondents against the petitioner on the ground that the petitioner has encroached upon the
national-
property belonging to the respondents. However, reasonable time is not given to the petitioner to cause a reply and thereafter seek consideration of such a reply which could be given by the petitioner, showing his title to the property in question. Full stop. Learned counsel would therefore submit that the impugned notice may directed to be treated as a show cause notice, and a reasonable time should be given to the petitioner to cause a reply along with the required documents. Full stop. Thereafter, the respondents should be directed to consider the same, and while giving sufficient opportunity to the petitioner, thereafter take any further steps in accordance with law. Full stop. Next para. Accepting the submission made by the learned counsel for petitioner, comma, the writ petition stands disposed of, while directing that Annexure A impugned notice dated 19th of September 2024 shall be treated as a show cause notice issued by the respondents. Full stop. 15 days time is given to the petitioner from today to cause a reply to the impugned notice at Annexure A. Full stop. The respondents shall await the reply that could be given by the petitioner, comma, consider the same in accordance with law, and if any opportunity of hearing is required to be given in accordance with law, the same shall be given to the petitioner, and thereafter steps shall be taken only in accordance with law.
Please.
Full stop. Next para. Ordered accordingly.
Obligation.
Number 6. Arvind H.
Proxy counsel in this case, my lordship. On-record advocate is suffering from viral fever. Kindly matter posted on Monday, my lordship.
A submission is made on behalf of the learned counsel for petitioner that he is unwell. Full stop. Release this matter on 20th of January.
7. Manorian.
Respondent has filed a complaint before the Consumer Commission, District Commission against a petitioner, and it was placed ex parte. Kindly see page 23. Issue notice to the OP unserved.
You have a state commission.
Allala, unserved.
Why have you filed a writ petition?
Principal, remand back to the Consumer Forum.
No, there is a state commission.
Swami, I am not merits of the case. It is the principle of natural justice.
Whatever it is.
Your Lordship may kindly see, it is unserved. I am not at all.
The same plea can be made
Kindly
before the State Consumer Forum. Why,
If it
when
is
a
merits of
separate
the-
mechanism is provided, why should you file a writ petition?
It is merits of the case. I can understand.
The same submission can be made before the State Commission.
Now, matters, Lordship may kindly.
For the respondent in this matter, my lordship, I've been served with a copy of the writ petition right now. We had filed a caveat. We were supposed, I can place the correspondence in record that we were not served with the copy with the annexures. We were not served a copy of the writ petition with the annexures yesterday. I had requested for the same.
Heard what is the contention?
Yes, my lordship.
It's an ex parte order. So therefore, set aside the order and permit me to contest the matter. Please. That is the submission.
I understand, my lordship. My only submission is like how this honorable court has said, he has to go before the state commission and not before this court. This is not the appropriate court to come before as of now.
Moreover, my lord, District Commission has order refund of entire 15 lakhs. I am not at all single. I am not submission regarding the
Instead
merits
of filing a writ petition, you could have gone before the State Consumer Forum.
merits ಮೇಲೆ ಹೋಗ್ತಾ ಇಲ್ಲ. Only because of
The same contention
defective
can be
procedure
raised
of the,
before the State
commission, my lord.
Consumer Forum Commission, isn't it? Is it not permissible?
If it is merits means you shouldn't. Otherwise, my lord.
Otherwise, it is not permissible.
Under 226, my lord, kindly see, my lord. Otherwise, whole my ಸಿಂಗಲ್ ಎನ್ ಪಿ ನಾನು ಅಲ್ಲಿ ಮತ್ತೆ ಅಲ್ಲಿ ಕಟ್ಟಬೇಕಾಗುತ್ತೆ 50% I should have pay the award amount. 7 lakhs rupees I should be pay. I'm not even Lakshmi kindly see my lord. 15 lakhs ಅಲ್ಲಿ 1 ಪೈಸನು ನೀವು ಕೆಲಸನೇ ಮಾಡಿಲ್ಲ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು they are
You have filed a caveat petition.
Please.
Yes, my lordship.
He has not served a copy.
I was not served. I have.
ನೆನ್ನೆನೂ ಕೊಟ್ಟಿದ್ದೀನಿ ಇವತ್ತು ಕೊಡಿ.
Please peruse this memo.
I served now.
Placing on proof the correspondence that was exchanged on WhatsApp yesterday.
Yes.
Sir.
Yesterday I sent WhatsApp also. Blood office has raised objections. Unless you served a copy, I am not posting.
Yes.
Again, I went to the browsing center. I sent an email. I kindly see the email
Lordship,
correspondence.
I was not served with an
attached
email.
this honorable court. my
I
lord,
was
the
issued
list.
this. I was issued a Word document on
Serve a
WhatsApp.
copy.
ಕೊಟ್ಟೆ ಈಗಲೂ ಕೊಟ್ಟಿದ್ದೀನಿ.
I just received
Yes.
it.
Please give a copy.
ಈಗಲೂ ಕೊಟ್ಟೆ ಈಗ just now.
I just received it.
Yes.
Learned counsel for the respondent submits that although a caveat petition was filed by the respondent, copy of the petition was not served on the learned counsel. Full stop. Learned counsel for the petitioner has today served a copy of the writ petition on the learned counsel for respondent. Next para, release this matter.
10th execution ಇದೆ. ಅವರು execution petition ಹಾಕಿದ್ದಾರೆ.
On 13th of January.
Great.
Till then,
ಏನಾಗ್ಬಿಡ್ತೀರಿ ಒಂದ್ ದಿವಸದಲ್ಲಿ? Yes.
Number 8. JMD.
The respondent bank.
Joint memo. Both parties are present.
The petitioner had sought for refund of the 25% deposited by him. He is the auction purchaser.
Huh?
The petitioner is the auction purchaser, my lords. He sought for refund of 25% deposited by him. Now he has approached the bank. To come to an amicable settlement, we are handing over the amount that has been sought by him, that is 11,87,500
All.
without interest. A joint memo is filed, my lords. I'll hand over the DD.
Please give it. The learned counsels on both the sides have filed a joint memo. Which is also signed by both the parties. Full stop. As stated in the joint memo, the petitioner herein has agreed to accept rupees 11,87,500 as full and final settlement at the hands of the respondent. Full stop. The petitioner, next para. Today, learned counsel for the respondent has tendered
Yes.
a demand draft.
Yes.
For a sum of rupees 11,87,500 to the petitioner.
Yes.
Full stop. Learned counsel for the petitioner submits that in view of the joint memo, the writ petition may accordingly be disposed of. Full stop. Next para. Accordingly, the writ petition stands disposed of in view of the amicable settlement between the parties.
Yes.
Full stop. Yes.
9. Vital BR party in person.
Lord, in this particular case, the association is formed and registered under the 1960 Act, which is the Inappropriate Act.
Huh?
This is an inappropriate act for the registration of the association. It's an apartment complex. So this is not the right act for registration. The society has to be registered either as a cooperative society or as a company, my lord. My
There
lord,
is
what
no
is-
interim prayer.
My lord,
There is no interim prayer.
there's no interim prayer, my lord.
Learned AG takes notice for response number 1 and 2. Issue notice to respond number 3. Learned counsel for.
Notice has been served, my lord.
Huh?
Notice has been served. a fixture has been made, they have not appeared. Respondent number 3 is done, my lord. So,
Then let it come up in B group then.
yes, my lord. A date may be given, my lord.
Service of notice is complete.
A date may be given.
The petitioner himself was the president of the same society. He also is a member.
ನಾವೇನ್ ಮಾಡೋಣ ಈಗ ಅವರು
No, at that time it was a different purpose.
What can we do? Only you can assist the court.
At
You
that
please
time it was a different purpose.
Find out. However, the contesting respondent number 3, those served with notice, has not entered appearance. Full stop. Matter may be listed in B group. Yes.
Then a date may be given, my lord.
No, sir.
I appeal for respondent number 5 in this matter.
In this case, Murada, the petitioner has contested the fishing rights in this front. The petitioner has quoted more than 8,62,000. That has bid has not been opened on the ground. The form number 1 has not been presented. He has filed appeal before the respondent number 2, my lord. In that 2, they are given direction to the
participated in the tender notification dated 6/12/2023.
Please.
Yes, ma'am.
In that, my lord, there is my bid has not been opened because there is a technical error has been occurred in the form number 1 has not been presented at the time of. I filed an appeal before the authority. The appeal in that authority, my lord, they are given note on note number 6 at page number 26, my lord. In that, the lordship may read note number 6 in this. ಶಿವರಾಜ್ ಟೆಂಡರ್ so and so ಅರ್ಜಿದಾರ 8,42,862 ಮೊತ್ತಕ್ಕೆ ಸಲ್ಲಿಸಿದ್ದು ಬಾಲರಾಜ್ ಅವರಿಗಿಂತ 6,60,000 ಹೆಚ್ಚು ಬಿಡ್ ಮೊತ್ತ ಇರುತ್ತದೆ.
ಇದರಿಂದ ಟೆಂಡರ್ process complete ಆಗಿ ವರ್ಕ್ ಆರ್ಡರ್ has been issued.
Yes, my lord.
In favor of respondent number
5.
What is your prayer in the writ petition?
My prayer in the writ petition is, my lord, we have quoted more than respondent number 5 is concerned.
But your tender was not accepted on technicalities.
No, technically, no, my lord. At that time, my lord, when filed an appeal, in that time they have accepted.
Learned AGA takes notice for response number 1 to 4.
Already notice has
My lord, respondent number 5 already appeared and filed objection and documents, my lord.
4.
5,
My lord. Respondent number 5, my lord.
You have filed objections.
Objections and
I
documents.
already filed objection.
I already filed, my lord. The matter is continuously posted in B group, my lord.
Respondent has entered appearance and has filed statement of objections. Full stop. List this matter in B group.
The date may be fixed because in the year 2024, my lord.
Yes.
Date, my lord.
Petitions are coffee estate owners, my lord. Trees were felled after permission, my lord. Certain rosewood trees and hardwood trees, which was auctioned by the government. Entire amount has not been paid. Sale proceeds were kept with themselves. Partial amount was released. Subsequent.
Same type.
Similar one. Yes.
ಇದರಲ್ಲಿ ನೋಟಿಸ್ ಆರ್ಡರ್ ಆಗಿದೆಯಾ?
Notice order ಆಗಿ statement file ಮಾಡಿದ್ದಾರೆ.
Statement of objection also.
You have filed.
And
What is your
also,
contention?
Lord, also in this matter, additional statement of objection need to be filed. Certain instructions I am yet to receive from the department. Like on 2 weeks time.
Learned AGA submits statement of objections have already been filed
on
in this writ petition.
27.
I have filed the rejoinder also, my lord.
Full stop. A rejoinder has also been filed at the hands of the petitioner.
Yes, my lord.
Full stop. However, learned AGA submits that additional statement of objections are required to be filed.
Please.
And the same will be filed
In 10 days. 2 weeks.
within a period of 10 days. Please. Full stop. Next para. Accordingly, release this matter on 22nd of January.
22nd.
Number 12. Samir Sharma.
For the petitioner, the respondent. Is the case of medical negligence wherein I had sought for consideration of my representations and conduction of a preliminary inquiry at the hands of the respondents. What had happened was I'd preferred two complaints. Lordship will find those two complaints at annexure A1 and annexure AB. At page number 33. What had happened was there was a case of medical negligence at the hands of doctors at Fortis Hospital and GM hospitals. I preferred a complaint before the police. As per three judgments of the Honorable Supreme Court, that is Jacob Matthew, Martin F. D'Souza, and Lalita Kumari, the police ought to conduct a preliminary inquiry in 15 days' time, at best 6 weeks, and then decide whether an FIR ought to be registered or not. Now, that was not done at all. In fact, your Lordship were to kindly see annexure E1. An NCR has been registered, a non-cognizable report has been registered by the police, and subsequently at annexure E2, page 208, an endorsement is issued by the police saying that it should go to the consumer forum. Now, challenging that, I have come before your Lordship. Now, on 13/9/2024, Lordship may kindly see this Honorable Court's order. This Honorable Court granted indulgence and directed the police to consider a preliminary inquiry. Now, pursuant thereto, on 21/10/2024, the police have filed a report before your Lordship saying that they have entrusted the matter to the hands of Victoria Hospital and they have to take a call. After that, the matter is coming up for the first time before your Lordship. So therefore, they have
What is it that the police can do in this matter, sir?
police has entrusted it to
Lord,
the-
parallel
proceedings
Please tell me, what is it that the police can do in this matter?
Their limited ambit is to conduct the preliminary inquiry.
If a case is made out in terms of the IPC,
Please.
then
And for that, and there are judgments on that point, the three judgments have annexed to the petition itself.
those are all general declaration of law.
Specifically, it
Wherever
says-
a complaint is filed, a FIR has to be registered.
Please, no.
There cannot be any dispute in respect of that issue.
No, the dispute was.
Admittedly, you are alleging medical negligence.
Please.
What is it that the police can do in this matter? Please
Police
tell me.
ought to conduct a preliminary inquiry.
What inquiry can they conduct, sir? Under which provision?
I've produced judgment for your Lordship. I'll show it to your Lordship. In fact, if your Lordship would kindly see, in the petition itself I've produced. Lordship may kindly come to page number 200.
And you have not even arrayed the person against whom you have made the
fact-
complaint.
in fact,
It's a party respondent to the proceedings.
In fact, with regard to that, it is also settled case law that at a pre-FIR stage, there is no requirement to issue a notice.
Again, you are going back to the same thing.
Please.
You are making a general statement. That is not what is to be considered in this writ petition.
If I may just clarify before.
When you are clearly alleging that there is medical negligence, what is it that the police can do in this matter? You please tell me.
They'll have to conduct a preliminary inquiry.
What inquiry, sir?
Your Lordship may kindly come to page 200.
Do they have the expertise to find out what is the
What they
medical
will-
negligence?
What they will have to do is, conduction of preliminary inquiry entails that they have to entrust it to a medical board.
That is what they have done now.
They have done now.
Yes.
Now subsequently,
And
my
my lord, an
grievance
inquiry
is
is
this.
being conducted as of today.
My grievance is this, it ought to have been done in 6 weeks.
And he has appeared, my lord, in the inquiry as well.
It has to
Which
be.
is the judgment you want to rely
Please,
upon?
Lordship may kindly come to page 200. This is Lalita Kumari.
Again, you are making the same statement, sir. Don't say anything regarding the general declaration of law.
Please.
A specific question is being put to you.
Please.
When you are alleging that there is medical negligence on the part of the doctors of a hospital.
Please.
What is it that the police can do in such situation? If there is any declaration of law at the answer of the Honorable Supreme Court, you please point out.
Your Lordship, I just point out, because there are judgments to this effect.
Regarding medical negligence and what the police can do.
That, just furnish the citations.
I am
Lordship,
again
kindly-
repeating,
This
if
addresses
there is
your
anything
Lordship's-
pertaining to medical negligence and there is a declaration of law, you please give it.
Please, this addresses your Lordship's query.
Yes, put it.
Now pursuant to these three judgments of the Honorable Supreme Court, which specifically deals with medical negligence and the fact that police has to conduct a preliminary inquiry by entrusting it to the hands of a medical board. Now I have produced judgments before your Lordship to show as to how this Honorable Court has interpreted these judgments. And they categorically say that you have to entrust it to the hands of a medical board. It has to be done in 6 weeks. Now my limited grievance is this. From what has transpired in the petition, they have handed it over to Victoria Hospital. Victoria Hospital, apparently, I'm given to understand, has come out with a report. Now, in furtherance of that report, it has been again placed before a vascular surgeon for further determination. My question is, my only submission is this. Lordship may kindly fix a date within which they have to conduct, they have to finish that preliminary
May
inquiry.
please see page
That is
241,
only
my
my
lord, the
limited
last
submission.
page of the writ petition.
Huh?
Last page of the writ petition, page 241. Inquiry is being conducted.
Now,
We have, my lord, one sec.
please, please.
Page 239 is a letter, my lord, sent to the KMC, my lord, asking that an inquiry be conducted. Inquiry is already initiated.
This was filed along with the writ petition itself?
I'll
Yes, my
clarify that,
lord,
Your Lord.
it's filed along with the writ
I'll
petition.
clarify
He
that,
knows
Your
that there is an inquiry going on.
Now,
He wants parallel proceedings to take place with the police.
now I'll explain.
Police have no expertise, my lord. He wants us to go on a chase.
Your Lordship, I am not here seeking something that the
Doesn't
police
make the
cannot
doctor
do.
also a party.
I am not here seeking something that the police cannot
Please
do.
see, my lord,
My
page
limited
241.
request is this. Indeed,
Inquiry is going on.
Yes.
Once the inquiry is concluded,
Now
if
he
anything
says,
else comes out, my
a
lord, we-
report is also given.
yes.
illa, report kottila. What has happened? I'll clarify to Your Lordship. I'm grateful that that point has come. What has happened is, instead of the police handing this to the hands of a hospital or a medical board, they have sent a notice to KMC, that is Karnataka Medical Council, and KMC pursuant to the notice issued by the police has issued a notice to the proposed accused or the proposed respondents. Now, my respectful submission is the proceedings before the KMC is a completely different aspect. It has nothing to do with criminal proceedings. In fact, if Your Lordship were to kindly see the Karnataka Medical Establishments Act, the remit of the KMC is very limited. Lordship were to kindly see section 15 of the Act. All that they can do is remove a particular doctor, disbar a particular doctor, that is it. Now, I am not for that. What I am seeking at Your Lordship's hands is a direction by Your Lordship that the police must conduct a preliminary inquiry and let them take a call whether an FIR ought to be registered or not. That is it. That is my respectful submission. So therefore, in fact,
Where is the judgment of the Honorable Supreme Court you are pointing out? Please
I'll
point
point
out
out.
that first.
Lordship may kindly come to page 103 for a moment.
103 or?
103 of my writ petition. 103 para 52. I'll come to the middle of the paragraph.
Yes.
A private complaint may not be entertained unless the complainant has produced prima facie evidence before the court in the form of credible opinion given by another competent doctor to support the charge of rashness or negligence on part of the accused doctor. The investigating officer should, before proceeding against the doctor accused of rash and negligent act or omission, obtain an independent and competent medical opinion, preferably from a doctor in government service qualified in that branch of medical practice who can normally be expected to give an impartial and unbiased opinion applying so and so. Thank you. Applying so and so test to the facts of the investigation. A doctor accused of rashness or negligence may not be arrested in a routine manner unless his arrest is necessary for furthering the investigation or for collecting evidence, or unless the investigating officer feels satisfied that the doctor proceeded against.
So
would not-
therefore, that step has been taken now by the investigating officer.
Issued an
Come on,
NCR.
no
He has
difficulty.
requested the board of the Victoria Hospital to
ಹೌದು.
look into the matter.
Please, please.
Yes.
ಇದಾದ್ಮೇಲೆ Lordship may kindly come to the next judgment of the Honorable Supreme Court, page 137. Page 137. The next judgment of the Honorable Supreme Court, Martin F. D'Souza. Lordship may kindly come 137, para 106. We therefore direct that whenever a complaint is received against a doctor or hospital by the consumer fora or by the criminal court, then before issuing notice to the doctor or hospital against whom complaint has been made, the consumer forum or the criminal court should first refer the matter to competent doctor or committee of doctors specialized in the field relating to which the medical negligence is attributed, and only after the doctor or committee reports that there is a prima facie case of medical negligence should notice be then issued to so and so.
Yes.
Now, if your Lordship were to last see Lalita Kumari at page 198.
Why should you go back to Lalita Kumari again, sir?
ಇಲ್ಲ ಅದರಲ್ಲಿ ಏನಾಗಿದೆ ಅಂದ್ರೆ the timeline has been laid down. I just
In
want to-
terms of the two judgments that you have read now,
Yes, yes, yes.
steps have been taken?
Steps have been partially taken.
Yes.
My only respectful submission that I'm seeking your Lordship's indulgence is this.
Yes.
Now, the Victoria Hospital apparently has taken a call. It has said that negligence agide. Subsequently thereafter, it has placed the report at the hands of a vascular surgeon because considering the nature of the negligence. And that copy is not furnished to me yet. Number one. Number two, now the vascular surgeon has to take a call whether an FIR ought to be registered, negligence agide or not. Therefore, my only respectful submission is Lordship may fix a timeline within which within which he reviews it and takes a call. That is my only respectful submission.
What information do you have?
My lord, we have asked.
You don't
Victoria-
have any information.
We, my lord, forwarded to the KMC. KMC has to conduct an inquiry. Once they find out whether this was a rash and negligent act, thereafter, my lord, we'll initiate any criminal proceedings.
Now, my grievance
This,
against
my
that
lord,
submission is,
they want parallel proceedings to take place. One, my lord, when an inquiry is going on, and another, my lord, a criminal proceeding.
now my grievance against that submission is this. Whenever I make this submission saying that the police must forward it to a board and then the board must take a call, a submission at the bar is made that we have already issued it to the KMC. My respectful submission is, your lordship may have to draw a distinction between the police taking some action in criminal law and the KMC taking some action under the provisions of Karnataka Private Medical Establishments Act. That has nothing to do with criminal law.
You don't want to read the portion of the judgments and you are stopped at a stage.
Not at all, not at all. I will go
Please
through.
read the further directions issued in this Martin D'Souza.
Please,
Para 106.
please, 106 is what I was reading. Your
Please
Lordship.
read.
Should I start from the beginning?
Yes.
We therefore direct that whenever a complaint is received against a doctor or hospital by the consumer fora or by the criminal court, then before issuing notice to the doctor or hospital against whom complaint has been made, the consumer forum or the criminal court should first refer the matter to a competent doctor or committee of doctors specialized in field relating to which medical negligence is attributed, and only after the doctor or committee reports that there is a prima facie case of medical negligence should notice be first issued to the doctor/hospital concerned. This is necessary to avoid harassment of doctors who may have ultimately found to be negligent, not be ultimately found to be negligent. We further want the police officials not to arrest or harass doctors unless the facts clearly come within the parameters of Jacob Matthew. I am not asking for anybody to harass anybody. My respectful submission is, this honorable court has granted indulgence. It has gone now, one level of scrutiny has happened.
Let us see what else is said in this case, whether
Yes,
the police are required to straight away register an FIR
I am not asking.
or was it required to direct you to go file a private complaint before the court? Because
Please,
the tenor of the directions given here in paragraph number 106 that you read out now
please,
clearly says
please.
the consumer forum or the criminal court.
I understand. I understand.
Police cannot do anything.
No,
So
no,
therefore,
please.
if you are required to go file a private complaint, please go and do
No,
it.
no, your lordship. The
Then
factual,
appropriate directions will be given by the court.
the factual situation
We
in that
cannot
case,
permit the police to take any action.
in fact, your lordship, in fact, to address your lordships, I understand what I have read out. Now, this was the factual situation in this case. Now, your lordship may kindly come to Lalita Kumari. Nana, one
It is clear from the judgments of the Supreme Court that you are required to go and file a private
not
complaint.
necessary. That is not the ratio of this judgment.
Huh?
That is not the ratio of this judgment. The ratio of this judgment is,
Learned AGA, please go through all these judgments
Please, my lord.
and apprise the court as to what is the directions issued by the Supreme
Please.
Court.
Please.
Whether they are required to go and file a private complaint and not go on insisting that the police itself should take up the matter on the written complaint given.
Please, my
Please go through all the judgments and the latest judgment and apprise the court.
lordship, ತಾವ್ ಇವತ್ತಿನ
Corporate.
ಮೆಮೊ ನೋಡಿದ್ರೆ, this honorable court has interpreted Martin F.
Learned
D'Souza.
AGA is requested to go through the judgments cited by the learned counsel for petitioner and apprise the court as to the law declared by the Honorable Supreme Court in such matters where medical negligence is alleged by a party and a written complaint is given to the police. Full stop. Next para. Release this matter on 15th of January.
Please. Today's memo may also be taken on record because this honorable court has interpreted today's memo, which I passed on.
You keep it with you, we'll see. Please give a copy to the.
I've served a copy. I've served a copy.
Yes,
15th, your lordship.
yes.
Please.
Number 13.
In this matter, I seek for a short accommodation, my lords. On record counsel is not well, my lords. Your lordship may kindly have it on Monday or Wednesday, my lords.
Please, at the request of learned counsel for petitioner, release this matter on 15th of January.
Great.
Oblique.
14. Akash Viti.
Petitioner in this matter, my lord, I request for a short accommodation. Writ of mandamus seeking representation, my lord. in regard to the illegal strike resorted by the government servant.
Illegal?
Strike resorted by the government servant against the petition number 1, my lord. And the same is in violation of provision of Karnataka civil servant conduct rules, my lord. We have also produced the rules at Annexure K, my lord.
Illegal?
Strike resorted by government servants, my lord, because government servants, they don't have legal or any kind of statutory right to hold any sort of strikes.
What is the
my
prayer
lord.
in the writ petition?
To consider
To
representation.
consider our representation made to respondent number 227, my lord, to take action against those government servants. Because the provisions.
How are you concerned?
My lord, they have resorted to the strike against me, my lord, the petition number
Against?
1. Against petitioner number 1.
Strike against petitioner number 1.
Yes, my lord.
What is the meaning?
Yes, my lord. They have said that the petition number 1 has made some flifty language to the Tahsildar. So that's why they have resorted to such strikes, my lord.
What do you mean by strike, madam? What is the meaning of strike against a private individual?
My lord, the thing is.
I am not able to
petition-
understand.
My lord, the petition number 1 is a former member of
Strike ಅಂದ್ರೆ ಏನು?
strike and where people hold strike if they are agreed.
ಏನು strike ಅಂದ್ರೆ?
Are where any people hold strike if they are aggrieved by any of the.
Strike ಅಂದ್ರೆ ಏನು ಅಂತ ಕೇಳ್ತಿದ್ದೀನಿ. What is the meaning of strike? And that too against a private individual.
My lord, the thing is the petition number 1.
What
is
we
a-
understand by strike is going on a demonstration on the
Yes, my-
streets
Yes, my
or
lord.
refusing to come and work.
Yes, my lord.
These may be the general manner in which a strike can be held.
Yes, my
What can be done against a private individual? What do you mean by strike against a private individual?
My lord, here the petition number 1 is a former member of Legislative Assembly, my lord, and also a president of Janata Dal. They have
Strike
alleged.
ಅಂದ್ರೆ ಏನಮ್ಮ? You are alleging that the officials
Yes, my lord, government officials.
have gone on a strike
Yes, my lord.
against the petitioner.
Yes, my
ಅಂದ್ರೆ ಅರ್ಥ ಏನು?
to defame the petitioner, my lord, because he is a former member of Legislative Assembly and also a president of Janata Dal. We have also produced photographs, my lord. Photographs are at Annexure G, page number 26.
Notices have been ordered in this
Yes, my
matter?
lord, notice has been ordered. There is also a newspaper article which was published, my lord, that is at Annexure H, page number 51. Krishna Reddy Virudha Naukarara Pratibhatane. Annexure H, page number 51, my lord.
Officials of BESCOM, is it?
Yes, my officials of respondent number 226, my lord.
Then why this respondent number 7 is here?
Sorry, respondent number 227, my lord. There are 7 respondents. Respondent number 227.
Respondent number 7 is BESCOM.
Yes, my lord.
The other
Respondents are Deputy Commissioner, Chief
ಏನಮ್ಮ?
Executive Officer, Zilla Panchayat, Deputy Director, Pre-University Board.
Zilla Panchayat ಇದೆ, Pre-University Board ಇದೆ. What kind of a petition are you filing, madam? Huh?
My lord, they being a government servants, they don't have any legal or
You,
statutory.
they are aggrieved of some action of yours and they have garrowed your house and they have raised slogans against you. And now you are coming before the court and saying, please find out as to whether they took permission before doing all these things. Where is the question of any government officer being given permission to do all these things? What is your prayer?
To consider our representation.
And do what?
And to take action against them because there was no such act or anything done by the petitioner as alleged by them.
So if you are aggrieved,
Please,
you go file a complaint. What action should the officers take against? You have not even named the persons who have done this. You are making a general statement that everyone came and garrowed your house. Action has to be taken against whom?
The officers of respondent number 227.
All the officers.
Not all the officers, my lord.
Then-
That's why we have made an detailed representation also that on the date of strike, whoever was not present in their office to take action against them. There are also an endorsement issued by respondent authorities where they have said that there was no such permission given by any of the authority to hold such strike.
My lord, page 30.
Service of notice is complete. Berkeley.
My lord, page 31.
Service of notice is complete. The respondents are required to file statement of objections, if any. Full stop. 4 weeks time is granted to the respondents to file statement of objections. Yes.
Let them, my lord, furnish a complete set, my lord. The set is incomplete.
Huh?
Set is incomplete, my lord. If they can furnish another set.
Learned counsel for the petitioner is once again directed to serve complete set of the writ petition along with annexures on the learned AG. Please.
Obliged.
And learned counsel for respond number 7.
Obliged.
Yes.
15.
The matter need not be listed for preliminary hearing once again. Yes.
Balakrishna, MR. And for the petitioner, my lord, 1 week time will be granted to comply the office objection.
A week's time is granted at the request of learned counsel for petitioner for complaints of office objection.
Much of.
15. Prasad BS. Can I request for a passover, my lord?
Say, huh?
Request for a passover, my lord.
Because
To
it's
got
a
information.
Passover. Covered by judgment, my lord. Similar set of facts. This Honorable High Court, my lord, granted parole. Because of this reason, my lord, the is convicted in the 324. He served a sentence already 9 months. It's completed. The petitioner grandmother, that particular is a grandmother died on 31/12/2024. For conducting a rituals, my lords, today is 8th day. Up to 14th day, my lords, he is the only son. He has to conduct all rituals, my lords. That's the reason I sought for parole for only for 7 days. 10 days. That's why, my lord, a similar set of situation, my lord, this Honorable High Court is granted in the order. And I also served the copy. Not any other purpose, my lord, sir. Only its petitioner father is in judicial custody. It is not a regular parole also, my lord. Para number 4. When did the death occur? 31/12. 31/12. 31/12. Today is the 8th day. Within 14 days, my lord, is this the first time you are asking for parole? Yes, my lord. It's the first, I surrendered as a convicted for a period of 1 year. I served the sentence 8 months already. This is the first time you are seeking parole? Yes, first time. Have you made a statement like that? Yes, ma'am. Or do you have any instructions?
My lord, I'll
As to
receive,
whether earlier also he had sought for parole?
I'll receive instructions 2:30, my lord, then
Huh?
2:30, my lord, I'll receive instructions.
Pass over.
Okay. 17, Abhinav Ramanandi.
For the respondent.
Matter is called out. There is no representation for the petitioner. Release this matter on 21st of January.
18.
Same, huh? Same, same order.
Orders. Serial number 19, Timana, withdrawal.
A week's time is granted to the petitioner. 2 weeks for furnishing the correct address. Huh? Learned Counsel for Petitioners has filed a memo dated 6/1/2025 stating that the parties, the rival parties, have amicably settled the matter. Full stop. However, when a compromise petition was filed before the trial court, the trial court observed that an order of stay has been passed by this court, and therefore the trial court is unable to proceed to accept the compromise petition and pass necessary orders. Full stop. Therefore, the petitioner seeks leave of this court to withdraw the civil revision petition for the reasons stated herein above. Full stop. Next para. The memo is taken on record subject to all just exceptions. Full stop. Accordingly, the civil revision petition stands dismissed as withdrawn.
Serial number 20, Irappa DM, FPF.
Two weeks' time is granted to the petitioner to furnish correct address and to take steps, take steps for service of notice on IA number 1 of 2024.
21, Shri Mallar Rao for the petition.
Because we yet to file a statement of objections, request for a week's time.
Huh?
We yet to file a statement of objections. I represent respondent number 1.
This Mallar Rao is the learned AAG.
Please.
Huh?
Please.
And he has filed a writ petition.
Not against.
State is not.
State is not.
All right. Non-compliance of office objections.
We undertake to come.
What do you say?
Miller's, they filed a challenging the allotment to the respondent number 2.
Correct. There is a direction issued
Miller's, the
on 37/2024 that respondent number 1 shall not make an allotment to establish retail outlet To respond number 2.
My lords, the letter of intent was issued before the writ petition was filed on 13th of June.
But it is alleged that the land is not converted
Land,
and therefore this order has been passed.
yes, but the
Ah.
agreement is not entered into.
Huh?
The agreement has not been entered into by the respondent number one. That we have not yet entered, my lords, in furtherance of the interim order itself.
Ah.
I'll file my statement of objection within a week.
My lord, I beg to appear for respondent number 2, my lord.
Ah.
My lord, all the conditions, my lord, which are mentioned in the brochure and the application have been fulfilled. My lord, according to the revised master plan, my lord, of 2015, even in agricultural land, my lord, fuel stations are permitted land use. So this writ petition will not stand, my lord.
Which is that provision?
My lord, in my statement of objection, my lord.
Your file statement.
Please,
of
my
objection.
Yesterday, page number
Huh?
4.
Yesterday they have filed. You have received a copy.
They have served the copy yesterday.
Learned counsel for respondent number 2 submits that he has filed statement of objections on behalf of respondent number 2 and has served a copy of the same on the learned counsel for petitioner. Full stop. Next para. Learned counsel for petitioner seeks for a short accommodation to go through the statement of objections and make submissions. Full stop. Release this matter on 16th of January.
Great.
In the file, my lord, the earlier order.
Again, it's not a conditional order. It is not a conditional order. Yes.
Great.
22. Patwal.
The petitioner in this case.
I am for respondent 5 and
Process has
16.
been paid, your
I haven't served copy to.
Non-compliance of office objections.
process is
Why you have
paid,
not
your-
complied office objections?
Your lordship will comply the office objection.
Learned counsel for
Weeks
the
time maybe.
submits that steps have been taken for service of notice on the unserved respondents this morning.
Yes, your lord.
Huh?
Yes, your lord.
Full stop. Office to verify and issue notice.
My lord, copy is not served to me.
I'll serve it right away.
In the meanwhile, office
Office-
objection shall be complied.
Please, please. Sir.
Full stop. Next para. You received a copy?
Please.
Yes.
23.
Your lordship interim order may kindly wait.
Interim order granted earlier stands extended till next date of hearing.
23. Devaya IS.
The petition in this matter, my lord. Lord, here is a case where there's a case of general rejection of tenders on the ground that the forest department itself concludes there is a mandate that, my lord, this is a tender in relation to the forest department. When tenders are submitted, all the bids have to be made excluding GST. I submit my bid excluding GST. After I am awarded the tender, the department itself concludes that the other unsuccessful bidders have included GST and then reject my bid, reject the entire tender and call for a fresh bid. The mandate given by the state of Karnataka is that all bids have to be submitted excluding GST. I submit excluding GST. I am declared successful. And this,
What interim order has been passed?
my lord, sets of interim orders have been passed. One is not to take, my lord, first was passed on 23rd of October, wherein interim order that is in relation to a stay of the further proceedings, the new tender that was called upon.
Respondents
Stay the tender,
are
retender
hereby
notification.
from reallocation of funds.
First, that was the second one, Lord.
Ah.
The first stay was that I had sought for was the retender notification dated 16/10/2024 was stayed. Thereafter,
Interim order as prayed for is granted.
I had sought for a stay of the retender notification. Thereafter, my lord, what the department attempted to do was the amount the amount that was allocated for this contract, they were attempting to literally render this writ petition infructuous by reallocating those funds for other contracts to say, even if you succeed, nothing will be available to you. So therefore, I got, insofar as this honorable court has granted a stay, insofar as reallocation also. As a matter of fact, on the last date of hearing, this honorable court had directed the state to place on record the entire file to ascertain whether the other bidders have submitted bids excluding GST. This honorable court had said that there should be a specific order under section 14 for rejecting the tender and had directed the government advocate to place on record the file.
My lord, I'll place it on next date, my lord.
Huh?
15th, my lord, I'll place it.
Learned counsel for the petitioner submits that in terms of the directions issued by this court on 19/12/2024, the learned AGA was required to secure records in relation to the bids submitted by the bidders and say as to whether GST amount was included in the bid amount or not. Full stop. Next para, learned AGA, however, seeks for a short accommodation.
15th.
Release this matter on 16th of
16th.
January.
Interim stay and interim orders may kindly.
Interim orders granted earlier stand extended till the next date.
Great. The next matter also is the same. It is a connected matter.
All right, same order.
Great.
In the meanwhile, office objection.
Office objection only, there's one, it may be dispensed with, my lord, I mean, it can be overruled because there is a tender notification, the subsequent tender notification. They've called, the office has directed me to produce a certified copy of that, which is a tender notification. It is put up on the portal. I've printed it out and submitted. If that may be overruled.
Office objection is overruled.
Grateful.
Yes. Correct.
25.
Hearing for the petitioner in this
KV,
matter.
Raj.
Furnishing a memo with regard to complaints of my interim order. Lord, I have not made the another payment of rupees 1 crore, my lord. I may be granted with.
Huh?
My lord, I have made the payment of rupees 7 lakhs as on 1/1/2025, my lord. But with regard to the payment of rupees 1 crore, I have not made that payment, my lord. Kindly, my lord.
It is made clear that in the event the deposit is not made as ordered above, not only shall the interim order stand automatically vacated, but the writ petition itself shall be liable to be dismissed.
Please, my lord.
Barkole. This court had passed an order on 12/11/2024 in respect of the interim prayer made in the writ petition, subject to the petitioner depositing 20% of the outstanding amount due as on the date of the order, within 4 weeks. Full stop. On 30/12/2024, this court has ordered that in view of the averments made in the affidavit accompanying the application, the interim order dated 12/11/2024 shall stand extended, subject to the petitioners depositing a sum of rupees 7 lakhs on or before 1/1/2025 and a further sum of rupees 1 crore on or before 6/1/2025. Which shall be deposited with the respondent bank. Full stop. It was also made clear that in the event the deposit is not made as ordered, not only shall the interim order stand automatically vacated, but the writ petition itself shall be liable to be dismissed. Full stop. Next para. Today, learned counsel for the petitioner has filed a memo stating that the petitioner has deposited rupees 7 lakhs with the respondent bank on 1/1/2025. Full stop. However, the learned counsel admits that the petitioner has not deposited rupees 1 crore as directed by this court. Full stop. Next para. In that view of the matter, the writ petition stands dismissed.
Number 26, Devaya Iyer.
Lord, there's another tender in the forest department itself. Here is the case, my lord. My bid again, at page number 44, my bid comes to be accepted by the department for carrying out certain reforestation works. Bid comes to be accepted. The contract is sent to the conservator of forests for acceptance. The conservator of forests then suddenly says that this is not within my purview, sends the matter back to the deputy conservator of forests. Here, my lord, the turn of events, the deputy conservator of forests refers the matter after the submission, after the selection of the bids, acceptance of the bids, refers it to some committee called as a technical committee, which this honorable court has held in numerous judgments that such a technical committee is not contemplated at all. A technical committee thereafter comes and rejects all of the tenders. And now, and the whole purpose behind this is that the department wants to now execute the contract. Entire contract is thereafter taken away from under the KTPP Act, which is mandatory that it has to be through the KTPP Act. It is taken away and the department attempts to execute the project. And I, my lord, kindly see page number 44, my lord. 42 annexure B, page number 46, I'm sorry, 46, the last paragraph. This is my acceptance of my bid. The order, in terms of it, may I read, my lord, the last paragraph. ಮೇಲೆ ವಿವರಿಸಿರುವ ಅಂಶಗಳ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಬಿಡ್ಡುದಾರರುಗಳಾದ ಶ್ರೀ ಡಿ.ಕೆ. ಶ್ರೀನಿವಾಸ್, that is the petitioner, my lord. Number 2 and number 3 ಇವರುಗಳ ತಾಂತ್ರಿಕ ಬಿಡ್ಗಳನ್ನು ಅಂಗೀಕರಿಸಬಹುದಾಗಿದೆ ಎಂಬ ಷರತ್ತೊಂದಿಗೆ ಟೆಂಡರ್ ಅಂಗೀಕಾರ ಪ್ರಾಧಿಕಾರ.
What orders have been passed?
My lord, here there's no orders have been passed because the government advocate was directed to submit, file objections insofar as this is concerned. That is why I have filed an application for consideration of an impediment prayer, because the department is attempting to execute the project now, the works now.
If it is not giving to any other person, it is doing on its own.
The department is
What
doing.
grievance can you have?
No, the grievance here is that the provisions of the KTPP Act have been violated.
It
The
is,
tender-
if the work is entrusted to another entity,
No, my lord, may I make this?
the department it's itself doing it.
The reason why
The question of complaints of the Transparency Act.
My lord, at the department, my lord, my submission is
Works
this.
is sought to be entrusted to any other entity.
Correct, my lord.
Then the question of following the provisions of the Transparency Act would apply.
The provisions of the reason, this is my respectful
It's not being
submission.
entrusted to any other entity. And the department itself has that wherewithal to execute
The reason why the department cannot execute the project, the reason being this, my lord, that if it has to be carried out by way of a tender under section 5, it ought to be carried out under the provisions of the KTPP Act. Now, how does the department overcome this? By rejecting the bid, which is otherwise accepted, by bringing it before a technical committee.
It is not being entrusted to any other person now.
It is not being entrusted. I
Ah.
can see. The reason being, my lord, now, the mandate under the law is that
The question is whether there is any need for the department now to comply any of the provisions of the Transparency Act.
the main provision of the Transparency Act, which is that all works, all government works have to be carried out and by way of a tender process, section 5.
That is, if it is being entrusted to any other entity.
How do they not entrust it to any other entity?
Ah.
By rejecting the bids unlawfully. That is what my contention is.
Sir,
The
you
bids-
yourself are saying it is not being entrusted to any other person.
It is not, my lord, may I make this submission? May I?
Please examine that. You notary, please secure.
My lord, my bid has been accepted.
Or
Now, having accepted my bid, my lord, the
petitioner, learned counsel for petitioner submits that the respondent, Department of Forests,
yes, my lord.
is seeking to execute the works on its own.
Right.
Without following the provisions contained in the Karnataka
Transparency in public procurement.
Transparency in Public Procurements Act, 1999. Full stop. Next para. The learned counsel for the petitioner and the learned AGA are requested to go through the provisions of the act and make submissions as to whether there is any need for a department to follow the provisions of the act, if the works are not being entrusted to any other entity and is being carried out by the department itself. Release this matter on 16th of January. Yes.
27. On
In this case.
awaiting for it.
Yes.
R1 is
This matter of the service of notice on respondent number 1.
but similar matter 25765/24 connected.
You know?
25765/24 same connected. WP 25765/24 same crime number 7.
ಅದು ಮುಂಚೆ ಆಗಿರೋ ರಿಟ್ ಪಿಟಿಷನ್ ಇವಾಗ
ಅದು ನೋಟಿಸ್ ಆಗಿದೆ ಸೇಮ್ ಕ್ರೈಮ್ ನಂಬರ್. ಅದು ನೋಟಿಸ್ ಆಗಿದೆ ಎರಡು ಕನೆಕ್ಟ್ ಮಾಡಿ.
ಕಾಲ್ ದಿಸ್ ಮ್ಯಾಟರ್ ಅಲಾಂಗ್ ವಿತ್
25765/24.
Yes.
Much.
Yes. Yes.
28.
Milords, I am for the petitioner in this.
ಬರ್ದಿರೋದ್ ನಂಬರ್ ಕೊಡ್ರಿ ಇಲ್ಲಿ. Yes.
Milords, serial number 28. I am for the petitioner in this case, Milords.
Yes.
Milords, I have complied the interim order, Milords. As per the direction, I had to file the undertaking affidavit. Milords, a week's time may be granted to file my undertaking affidavit. On 13/12/2024, I filed my memo along with the proof of compliance of the interim order, Milords.
29th of November, an interim order was passed, which the petitioner has complied. However, in
Yes.
the order, it was, the petitioner was directed to file an undertaking affidavit.
Undertaking affidavit.
Clear the entire loan within a reasonable time. That affidavit has not been filed. That.
I will file it on 15th itself, Milords.
You are filed.
No, I will file it on 15th, Milords, with your permission, Milords, because today they have some inconvenience. They are out of station, Milords. So, in the meanwhile, I'll also.
Petitioner submits that this court had directed the petitioners to file an affidavit stating that the petitioners will pay
The entire loan within a reasonable
the
time.
entire loan amount within a specified period. Full stop. However, the affidavit could not be filed. Therefore, the learned counsel.
Yes, Milords, learned counsel for the petitioner.
Counsel submits that the matter may be taken up on 15th of January.
Yes.
And the affidavit will be filed.
Yes. Until then, interim order may be extended.
Accordingly, release this matter on 15th of January. Interim order granted earlier stands extended.
Grateful, Milords, grateful.
29. Mohana Chandra P.
My lord.
Non-compliance.
Office of the regarding Annexure A, it is a readable document, legible. And Annexure C, NOC, I am not relying upon such document. Hence, office objects kindly be overruled.
Huh? Legible copy of annexure AC.
AC, A is a readable and legible copy. Your lordship kindly see page number 9.
Office objection is overruled. Huh?
You have to prefer a PIL because.
Yeah, no, what is the prayer?
My lord, the respond number 3 has submitted application.
Wash. Impugned order dated 15/7/2024 at annexure
G.
G and H.
Yes.
No objection issued under the explosive act.
ಸ್ಫೋಟಕ ವಸ್ತುಗಳ ದಾಸ್ತಾನು ಮಳಿಗೆ ಸ್ಥಾಪಿಸಲು ನಿರಾಕ್ಷೇಪಣ ಪತ್ರ
Yes.
ನೀಡುವ ಸಾರ್ವಜನಿಕರ ಆಕ್ಷೇಪಣೆಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ವಿಚಾರಣೆ ನಡೆಸುವ ಕುರಿತು.
I submitted objection, the detailed objection to the respond number 2. He has not at all considered objection. No inquiry was conducted as per rule 103 of explosive rules. And rejected my objection and issued NOC to respond number 3, my lord.
no reason was assigned, why my objection was rejected. Blindly and mechanically pass the order.
For the purpose of possession
No,
or use of explosives from a magazine as per approval of class 2 and 6 in a magazine as mentioned in part 1 of schedule 4. Nitrate mixture, detonating fuse, electric and ordinary detonators. ತಹಸೀಲ್ದಾರ್ ಗುಡುಬಂಡೆ ತಾಲೂಕು ರವರ ವರದಿಯಂತೆ ಸದರಿ ಜಮೀನಿನ ಸುತ್ತಮುತ್ತಲು ಕೃಷಿ ಜಮೀನುಗಳಿದ್ದು 500 ಮೀಟರ್ಗಳ ಒಳಗೆ ಧಾರ್ಮಿಕ ಸ್ಥಳ, ಶಾಲಾ, ಕಾಲೇಜು ಇರುವುದಿಲ್ಲವೆಂಬ ವರದಿ ಸಲ್ಲಿಸುತ್ತಾರೆ. Who are you?
I am residing adjacent to the place, eligible place, storage.
ಏನ್ ಅಡ್ಜಸ್ಟೆಂಟ್ ಅಂದ್ರೆ?
ಹತ್ತಿರದಲ್ಲಿ ನಂದೆ ಅವರ your lordship kindly see my objection. Next year F to page number 21 ಅಲ್ಲಿ ಕಾರಣ ಸದ್ಯ ಸರ್ವೆ ನಂಬರ್ 34/5 1 ಎಕರೆ 13 ಗುಂಟೆ ಜಮೀನಿಗೆ
Where are you reading?
page number 21. Representation. Paracel.
Representation.
Yes.
What is the finding of the?
He has not assigned reason. Blindly as he has rejected my application.
They have taken the opinion of the Tahsildar. Please come to page number
as per law
25. 25.
Yes, as per law
5. Tahsildar Gudibande Taluku. Odi.
ಕುಟುಂಬದ ವರದಿಯಂತೆ ಸದ್ಯ ಜಮೀನು ಸುತ್ತಮುತ್ತ ಕೃಷಿ ಜಮೀನುಗಳಲ್ಲಿ 500 ಮೀಟರ್ ಒಳಗೆ ಧಾರ್ಮಿಕ ಸ್ಥಳ, ಶಾಲಾ ಕಾಲೇಜು ಇರುವುದಿಲ್ಲವೇ ವರದಿ ಸಲ್ಲಿಸುತ್ತಾರೆ. ಅಂತೆ ಜಮೀನು 6 ಜಮೀನು ಸ್ವಾಧೀನ ಸಂಬಂಧಿಸಿದಂತೆ ದೂರದ ಹಕ್ಕು ಇದ್ದಲ್ಲಿ ನಾವು ಜಮೀನು ಸ್ವಾಧೀನತೆ ಬಗ್ಗೆ ನಾವು ಇದು ಮಾಡ್ತಿಲ್ಲ. I am the existing owner of the storage of godown.
What is the requirement of law?
Law ಏನಂದ್ರೆ before issuing a license NOC.
What is the requirement of law, sir?
Call for objection from the general public.
ಆಯ್ತು, ಏನ್ objections? What objection can be raised?
Your lordship, page number 21. I submitted detailed objection.
ಅದ್ರ ಬಗ್ಗೆ ಏನ್ರಿ?
ಯಾಕೆ ನಮಗೆ ಡೇಂಜರ್ ಉಂಟು?
What is the requirement of law? I'm asking you.
Requirement law after obtaining a
provision ಕೆಳಗಡೆ
103 of explosive rules.
ತೆಗಿರಿ. Explosives rules.
Yes.
You have extracted that?
Yes, your lordship kindly found in the order itself. Page number 24 order ಅಲ್ಲಿ.
Yes.
ಇದು ಇಂಗ್ಲಿಷ್ ಅಲ್ಲಿ ಉಂಟು ಕೆಳಗಡೆ. The district magistrate on receipt of application report in sub rule 1 shall make verification of the antecedent of the applicant, lawful possession on site, genuineness of the purpose, interest of the public, and any other verification or enquiries as may be specifically required by the licensing authority to be carried out, if any, and on any other matter as deemed necessary. A. For verification of interest of public, the district magistrate shall forthwith cause a notice to be published calling upon the public to submit objections, if any, with the reason thereof, within a period of 1 month from the date of publication notice, and specifying the date, time, and place for consideration of objection by him, where the site of the proposed premise lies within 1.5 kilometers of the limit of jurisdiction of any town planning, municipal authority, or port, or any or airport, or the satellite or space craft launching station, or similar establishments of national importance. The district magistrate shall cause the notice to be served to such authority or establish the day of hearing for consider objection shall be fixed as early as possible. After the expiration of the period of 1 month from the date of publication notice, on receipt of objection, district magistrate shall call upon the person raising objection and also the applicant, giving not less than 7 clear days before the day fixed for hearing of consideration of objection. On the day fixed for hearing or any day to which such a hearing may be adjourned from time to time, district magistrate shall hear and any objection relating to the purpose of no object certificate and shall make such inquiry as he may deem necessary to assess justification of such objection. In this case, no inquiry was conducted.
Sir, what what is the objection that can be raised? I'm asking you,
Yes.
what is the minimum distance that has to be maintained? What is the provision of law?
They were also provided opportunity.
Huh?
But no, because I am residing adjacent to.
What is
Yes.
the provision of law, sir?
Short date में kindly begin. Short date को तो बिना नहीं.
Without even reference to the provisions, you are simply raising objections.
Because you want
That the provision says so.
Yes.
My house is situated within
Yes.
so and so distance.
Here means object.
Where is the provision of law?
You are also kindly give me short date. I will find.
Purple. The petition is bereft of any provision of law which the petitioners can point out to while contending that the minimum requirement in terms of the provisions of law have not been followed by the respondents. Full stop. Next para. At this juncture, learned counsel for petitioner seeks for a short accommodation. Full stop. Release this matter on 15th of January. Note renewal. Please verify.
Yes.
Yes.
Number 30, Kalyanar.
Appear for the petitioner. My lord, copies are served on the, my lord, hand summons is served on the respondent number 1 and 2. I'm filing the acknowledgement for having served.
Huh?
Respondent number 1 is the State Tourism Development Corporation.
Learned counsel for the petitioner. Has filed a memo along with acknowledgement and submits that respondents number 1 and 2 have been served with the hand summons. Full stop. Ian, what is the grievance?
My lord, the petitioner is a my lord, was awarded a tender for supply of manpower. My lord, bills were not cleared, my lord, for 3 months. Therefore, my lord, he had submitted several representations.
Yaru, response number 1 and 2, na?
1 and.
So unless they come before the court, nothing can be done. Please ensure that they come.
My lord, I may also be permitted to notify the, my lord, the panel council.
Yaar idhar?
I'll verify and
I don't think they are there. Next para. Learned AGA is requested to inform respondent number 1 and 2 to enable their representation before the court, since this matter, in this matter, response number 1 and 2 are the contesting respondents. Yes. Release this matter on 21st of January.
Much.
31, Rohit R. Kumar.
I appear for the petitioner in this matter.
Advocates
Association matter. Monday in
Yes.
the other two matters are also connected.
Yes.
This is 3 and 4, Your Lordship.
2
and 3 will be.
It's mine. I filed an application, my lords, in 34 main matter, 31 main matter.
Yes.
Again seeking the same relief, my lords.
Yes.
Your Lordship.
Yes.
35836.
ಎರಡು ಇದೆಯನ್ರಿ ಎಷ್ಟಿದೆ?
Please,
The new matters, there are two.
please.
ಒರಿಜಿನಲ್
one
ಮ್ಯಾಟರ್
notice-
ಇಂಪ್ಲೀಡಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಇದೆ.
34305 is not yours.
My lords, I filed IA in that. 34305.
ಅವ್ರದ್ದು ಹೊಸ ಮ್ಯಾಟರ್ಗಳನ್ನೇ ಆಡ್ ಆಯ್ತಲ್ರಿ ಅದು ಕೊಡ್ರಿ ಆ ಫೈಲ್ ಕೊಡ್ರಿ.
31.3, 123 of 25. 31.3.
31.3. 123 of 2025.
31.2, your lordship.
31.2 also is the previous
31.2
matter.
and 31.3 ಎರಡು
Please,
ಕೊಡ್ರಿ.
That two
please.
new matters.
I'll finish 3, then 2, then it will be.
Thirty-one point two ಕೊಡ್ರಿ. 31.2 ಅಲ್ಲಿ ಇದಲ್ರಿ 35 ಅದೇನಾ?
836, 35836.
It was filed by Mr. Amritesh.
Please,
No, no. Diksha,
Dena?
please,
Amritesh.
please,
Dena?
please.
Diksha Amritesh is the petitioner.
This is specifically only on the issue of reservation, your
Petitioner.
lordship.
Learned AGA.
Your lordship, in this already,
Notice has been ordered.
this had come up in the vacation.
31.2 notice is ordered.
Please,
Ordered.
please.
31.3 nala.
31.3
3 nala.
31.3 ಅಲ್ಲಿ learned
3.
AGA takes notice for
We have already served them.
respondents number 1 to 4. Who is appearing for the Advocates Association? Who
Copies
is
have been
appearing for
served.
Advocates Association?
The,
In all these matters?
the acting general secretary is.
ಯಾರು?
Arun.
Mr. B.M. Arun.
ಇಲ್ಲ ನಾನಿಲ್ಲ ಅಡ್ವೊಕೇಟ್ಸ್
He is not appearing. No, he is
ನಾನಿಲ್ಲ.
not.
ನಾನು ಪ್ರೈವೇಟ್ ಪಾರ್ಟಿಗೆ ಪೆಟಿಷನರ್ಗೆ ಅಪಿಯರ್ ಆಗ್ತೀನಿ ಫಸ್ಟ್ ಮ್ಯಾಟರ್ ಅಲ್ಲಿ.
ನಾನು ಸೆಕ್ರೆಟರಿನ ಅಪೇರ್ ಆಗ್ತೀನಿ.
ದೇ ಆರ್ ಸರ್ವ್ಡ್. Secretary is served in our matter for advocates association.
Secretary is before the
Yes.
court.
ಅಲ್ಲ, in other three matters, association is not represented?
ಇದೆ.
ಯಾರು? Who is represented?
Advocate ವಕಾಲತ್ ಹಾಕಿಲ್ಲ.
ಹಾಕಿಲ್ಲ.
Secretary was present before the court. Secretary was present before the court on the earlier occasions.
It says Gayatri, is it?
ಆ ಸರ್ವಿಸ್ ಆಗಿ
Anyway, the government has been served, and I think Natraj. Who is taking?
all of them were served and they were present. From the president, secretary, treasurer, everybody were present.
No, no, no. You take notice. We have served it. Whoever is from the association, they can take notice. Since anyway they are here today.
No, secretary has been shown as a party. He is before the court.
One set was given. Okay, one set of yours was given. I'll give you one more set. It's on the same issue. I'll give you one more set.
ನೋಡ್ರಿ ಇದು 35836 ಆರ್ಡರ್ ಶೀಟ್ಸ್ ತೆಗೀರಿ. ಅದರಲ್ಲಿ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 6 ಅಡ್ವೊಕೇಟ್ಸ್ ಅಸೋಸಿಯೇಷನ್ ಗೆ ನೋಟಿಸ್ ಆರ್ಡರ್ ಮಾಡಿದಾರ ನೋಡಿ.
Your lordship, all of them have been served. And memo acknowledgement is also.
Girish Kumar appears for R6. That is the association.
R6.
Girish Kumar's name has been
Girish
shown
Kumar.
against R6. That is.
Girish Kumar R.
ಹೌದು.
Where is he? Where is he?
Girish Kumar
ಇಲ್ಲ ಅವ್ರ ಪರ ನಾನೇ ಇರ್ತೀನಿ. ಅವ್ರ ಪರ ನಾನೇ ಇರ್ತೀನಿ.
Shri Girish Kumar R, who has entered appearance for the Advocates Association, Bengaluru, in the connected matters, is requested to take notice for respondent number 5.
6.
Full stop.
In our
Learned
matter,
counsel for
6.
the petitioner is directed to serve copies of the writ petition along with annexures on the learned AGA as well as learned counsel for respondent number 5. Yes.
Let my friend make a submission.
ಎಲ್ರಿ ನಿಮ್ಮ ಇವ್ರು ಬರ್ತಾ ಇದಾರಾ ವಿವೇಕ್ ರೆಡ್ಡಿ ಅವರು? ಹಾ ಬನ್ನಿ. ಎಸ್
Please. Your Lordship has the 31.2, Your Lordship. Please. What they had raised is, one is that the bylaws would have to be amended. Might I take Your Lordship to the bylaws, which is at page 25? Page 26 onwards, Your Lordship.
yours is WP 123.
No, no, no.
No, yours is the other one.
Yeah, mine is the one.
Page?
Your Lordship, page 26, Your Lordship,
Ah,
please. Your Lordship, may I kindly see 3,
yes,
3C.
yes.
To take steps to the physical, social, intellectual advancement of his members. Social advancement is already contained in the very bylaws. There would not be any necessity for a specific amendment to the bylaws to bring in these provisions where there would be a requirement for reservation. When there is already the objectives of the bylaws have already stated that it is for the social advancement, it is imperative that they bring in this, and therefore, at this point of time, bylaws amendment might not be necessary. The other one is at 3I. To do everything incidental to or necessary for the achievement of all or any of its objects, which is at 3, either singly or in collaboration with the other law institutions or associations having the same or similar objects. Now, the other associations have already implemented it, especially the Supreme Court bar, which they have already implemented based on the Supreme Court directions. And therefore, if we are to read 3C and 3I together, then the amendment at all would not be necessary, Your Lordship. The next, Your Lordship, may kindly turn in this very, the provisions, Your Lordship, for amendment, if it is there or not. Lordship may kindly turn to page 37. Under 33, there's electoral roll. Lordship has page 37. Number 33, Your Lordship, electoral roll. In that, if Your Lordship goes to the last one at F, any correction, deletion, inclusion shall be carried out by the General Secretary. All of this, Your Lordship. In this, they had already changed it to 15 days from after 60 days. This was something that was done even without an amendment. Your Lordship, with respect to amendment specifically, the provision ultimately would be at page 47, at 64, Your Lordship, which says bylaws. Number 2, the bylaws shall, as soon as may be after they be made, be placed before the general meeting of the association convened for any purpose, which shall have the power to affirm, modify, or rescind the same, and the bylaws shall have the effect. Therefore, I have some other bylaws of some other associations, Your Lordship. With respect to amendment and all of that, there are specific provisions. Whereas in this, they say now amendment madbeku anta. Idralli, ultimately they have affirm, modify, or rescind. That is all. Amendment provision itself, their bylaws itself is very defective. And they have here only these provisions wherein either modify. They don't even have an amendment provision. All I'm saying is, while their bylaws are itself defective, number 2, there is no specific mention of amendment. And number 3, when there is already a provision under 3C and I, where it talks about social reforms and it talks about social advancement, then even without a bylaw amendment, Your Lordship would be at liberty to proceed directing them to implement the same. Lordship, next is coming to, they state that 60, I've already taken Your Lordship to 64.2 in the bylaws. Now, Your Lordship may kindly see at page 66. Lordship has 66, which is the Supreme Court's judgment in Kaushik. Lordship may kindly see in that at page 70, paragraph 6. We are, however, of the view that notwithstanding any resolution, this would be the key issue. We are, however, of the view that notwithstanding any resolution passed by the general body of the SCBA, some of the posts in the executive committee must be reserved for women members of the bar. So what the Supreme Court says is that notwithstanding anything that you have to say, even if you're objecting to it, even if there is no provision, we are of the view that you will have to reserve some seats. So this, if it is read along with their objection stating that bylaws would have to be amended, even in a situation where it has been rejected, the Supreme Court has held that you would still have to make the provision in Kaushik's matter, Your Lordship. Your Lordship, the Delhi High Court, they had mentioned that elections are already fixed in our matter. They say elections is fixed for February 2nd. In Delhi High Court, the elections were fixed for October last year, Your Lordship, October 2024. Honorable Supreme Court had directed, and Delhi High Court said that we will await the directions of the Supreme Court and postpone the elections from October to December 2024. And therefore, if the Delhi High Court could have postponed, awaiting the result of the Supreme Court, and when Supreme Court observed that the reservation would have to be made, subsequent to the postponement, they implemented that. Therefore, now to state that we have already fixed our date as 2nd, it is absolutely no tearing hurry. If we have waited for 1-2 months, we can wait for another month. There would be no necessity at all. If they still think that we would still have to proceed by 2nd, I am sure that even after giving this, complying with the Honorable Supreme Court's direction, they could still keep that post reserved as they have done their treasurer post, keep it for women, and of course the 1/3 posts of the other members, all of that. Your Lordship, I pass on this, the Delhi High Court order. Sorry.
It is there in the other one.
Yeah. No, this is just to say about adjournment.
Now calendar of events are issued today morning.
All of that
That's
is
the
already
latest
done, Your
development.
Lordship, even in Delhi. From October to December, they postponed it just to await the Supreme Court directions. Lordship may kindly turn to paragraph 8, Your Lordship. Your Lordship, para 8, keeping in view the aforesaid Supreme Court order dated 26 September.
Paragraph number 2.
2, please. The request stems from the fact that 2 writ petitions were filed before this court by a few women lawyers seeking reservation in the executive committee. Since the writ petitions were adjourned to 27 November, 2 special leave petitions were filed by women lawyers challenging the order of adjournment. It is stated that special leave petitions so-and-so were filed by so-and-so respectively. It is contended that both the SLPs deal with the issue of reservation for women lawyers in the ensuing bar elections. It is further contended that in so-and-so matter, the prayers to reserve at least 2 seats in the top executive position of Delhi Bar Association on a rotational basis and reserve 3 seats in the executive committee for women lawyers apart from the other prayers. It is stated that in Shobha Gupta so-and-so, the relief claimed is reservation 33%. I understand that Your Lordship is trying to say that this was already filed in Supreme Court. I'm not on that aspect at all. I'm only on that.
Because of that, the adjournments were done by the High Court.
The aspect of why it was done, Your Lordship.
Why I said yesterday itself.
Please.
In fact, in the latest order, the Supreme Court has already issued directions.
Correct.
It has called for information
Correct.
in respect of the other bar council, bar association.
Correct.
And the Supreme Court itself may pass an order.
Please.
But at this stage, for this court to pass such an order is not permissible.
I'll still may make my persuasive attempt for another 5 minutes alone, Your Lordship. The reason I'm reading this is not because it on the reasons as to why they adjourned it. I'm on the aspect that heavens won't fall, no damage would be done. When in a similar matter, they were able to adjourn the matter even after the fixing of the election date. It is still possible, and therefore it is not as if it is impossible that once an election date is fixed, it cannot be postponed, Your Lord. That's the only aspect I am on. Your Lordship, on,
The general law
Please.
is otherwise.
please.
Commencing from Ponnuswamy,
Ponuswamy is judge, please.
the Supreme Court has consistently held, and this court also has followed the directions issued by the Supreme Court.
Please,
No interference can be caused by the court
please.
once the process of election has commenced. It is impermissible.
Your Lordship, in this very case, the process had not begun. Even as of today, they're stating calendar of events. It should have been done by 30th, last date. It wasn't done. Only after notice was issued in this matter, hurriedly it is being done. That itself is a reflection of what is behind their minds on this aspect, Your Lordship. Because just mere lip service saying, oh, we are all for it, doesn't, ultimately they have to walk the talk. If they really are for it, by now it would have been implemented, which they have not done. Your Lordship, in Fawzia Rahman's case, though it is pending, Your Lordship, as Your Lordship stated.
There are certain difficulties even for the other side.
Please.
Now, as of now, the term of the managing committee is over.
Yes.
Yes.
So even a statement cannot be made by them.
True, they do not have the.
But, as a general statement, the learned senior counsel yesterday said, we will not have any difficulty.
Yes.
In fact, this court can also make that observation. It's not difficult. Having regard to the directions issued by the Supreme Court, it is clear that the intention is reservation should be given. However, the extraordinary powers which are available to the Honorable Supreme Court is not available to this court.
Your Lordship, under 142, I understand.
Yes.
But 141 then must be read in conjunction.
This cannot be read as a precedent under Article 141.
226, I understand limited powers, but if we are to follow the directions of the Supreme Court, then under 141, we can directly implement
The
it.
process has already commenced. The Supreme Court itself may issue such directions. So instead of filing this writ petition, you should have simply gone and filed an application there.
Yes.
Your Lordship, we still had faith.
Even now.
We still had faith in our brothers, but they let us
No,
down.
no,
That is all.
They also
And
cannot
we are
make a
ready.
statement now. That is what
We are
I'm
ready.
saying. It is not possible for them also to make such a statement.
Today, I am not a president, actually.
That is what.
Technically, they have.
Maybe, Your Lordship,
I'm
even in
continuing for
that,
the purpose of.
the office in their matter, which is at 30, even in that, the previous roster, Your Lordship, in fact, this Honorable Court had directed that they have their meeting. When was their meeting directed to be held? On the 20th, 19th. 19th, they were directed, just general body meeting, Your Lordship. There, and it is there, part of the order. So at this point of time, even without that, for them to proceed, Your Lordship,
No
then it
meeting
would-
on 19.
There was no direction, my lords.
there is,
No
there is.
direction,
No, there is, there is.
Submission.
No
On 19th
direction.
general body.
There was no direction.
Going to be.
Your Lordship, might I just read, office bearers who are present before this court submitted that the draft voter list has been published and the final voters list will be published on or before 2012-2024. The office bearers of the Advocate Association to convene the annual general body meeting on 19/1/2025. We have not yet arrived at.
No, that is general body. That is
See,
not, that is for
maybe.
elections.
Maybe.
No, no.
I don't understand the high power committee or Mr. Arun's over enthusiasm in this matter to state that
No, I
even
am
19-1 is
clarifying the
only with
facts.
respect to.
Their intention is that election should be held to the association as soon as possible.
As soon as possible, Your Lordship, at this point of time, even if Your Lordship is of the view that let it be on 2nd, it would still not be too late for the women members to even at this point of time start their even.
Fact, may I just point out on the bylaws? Because if the submission is made, the calendar of apparently today morning they have released it. If that is the submission, kindly just see the bylaws. Kindly may I take my lords to the bylaws provisions 24. Just can we see it?
Yes.
Sorry.
Term of the office.
Term of appointment of publication of calendar of events. Publication of calendar of events.
In fact, 24 is also relevant. Term of office of governing council
Term
so
of
elected,
office
general body
also,
shall cease.
that is 3 years. The reason term of office is important because if we miss this, it is for another 3 years that the elections will not happen. Then my lords kindly see publication of calendar of events. Publication of calendar of events, it says The returning officer shall by a notice published in the notice board fix the calendar of events.
Where is that?
My lords, I think that is
38.
38.
38.
38. I think the numbers are not there.
Your Lordship, in my
30
14 page number.
14, page 14.
Ah.
Publication of calendar of events. The last date for receiving nominations shall be 6 clear dates from the date of publication of calendar of events. Today, even if they have published it today, in fact, as per the orders of this honorable court, it was to be published on 2nd. It is still not published. If they say they have published it today on 8th, the next, the election can only be 1 month as per their own.
No, it is already published, my lords, on 2nd.
And if the date it is published from 6 days onwards, the nomination period is still there. So there is no bar, even if today this honorable court were of the view that as per the orders of the honorable Supreme Court, one office bearer, which is the treasurer, and 1/3 of the other members. The other members in the High Court are 7. So 2 members out of 7, if they are to be there, clearly even the calendar can comply with. We don't even need to delay it, my lords. My lords, may just kindly give me one more.
Those directions are not in respect of the Bangalore Advocates
I'm saying
Association.
this court's directions. our
Therefore,
court's
that is why I
directions.
said, no.
The
Issue never came up.
no.
If for the first time, you are bringing up this issue.
Of course.
You have filed 2 writ petitions,
Yes.
one impleading
Application.
In fact, one
voicing this
yes.
concern, and you are seeking a direction that in terms of the directions issued by the Honorable Supreme Court in the case of the Supreme
SCBA
Court
and
Bar
Delhi Bar,
Association,
yes.
please direct that there shall be reservation for women. It is not possible, madam.
My lords, we with great respect, the application, the first implement application in Mahesh Nayak was filed on 20th, 1 day after the.
What is the use of filing
now,
an impleading application?
The
requirement of law is, if there is a provision already made in the bylaws for reservation and they have not implemented that, you can say, yes, though there is a provision, they are not permitting such
with
reservation.
great respect.
There is no such
No,
provision.
with great respect, there is no such provision. That is why we are before this honorable
Correct.
court. There
So
is no provision.
therefore, firstly, we
Because-
will have to ensure that there is a provision brought into the bylaws,
With the
or it is only available with the Honorable Supreme Court to issue such directions that divorce any such amendment. You please ensure that there is reservation, then accordingly it can be done.
with great
That is
respect.
why I am saying, even now, please go before the Honorable Supreme
With great
Court, file an
respect,
application.
Yes.
my lords,
There's
my
directions are
submission
issued
is
that,
when
they are
the
bound to
honorable
comply with.
Supreme-
You have to.
when the
That directions cannot be issued.
my lords, when the honorable Supreme Court in fact noted categorically that there are no, even in the SCBA and the Delhi High Court, there were no such
You
provisions.
are right. That is why I am saying that powers are exercisable under Article 142. That is not available to this
My
court.
lords, with the law, my
If
lords,
such directions
powers
are
under
given,
226.
it will be contrary to the laws
With
set by
respect, my
the
lords,
Honorable
the-
Supreme Court.
Yes.
itself.
Respect, it will in fact be in compliance with the orders.
The provision for reservations made in Article 15 and 16,
Yes. Yes.
it is only an enabling provision.
Yes.
My lords, the.
Absolutely.
It is an
14,
enabling,
15,
I am
16.
talking of the express provisions of reservation made in the Constitution.
Yes.
Even that has been held by the Supreme Court as an enabling provision.
Here, my lord.
The appropriate government is required to act upon it.
Yes.
If it finds necessary that reservation has to be given to a certain section,
My
By a
lords, here,
they have to make a law.
my lord.
Your Lordship, just 2 other points. May I just pass this on your Lordship? That's it. Should be- Your Lordship, just with respect to the Honorable Chief Justices, the second page, just that portion I will read, which is the only, might I, please, Your Lordship.
142 presidential value and article presidential.
No, I will just read this is,
Yesterday itself, I said this.
please,
All of us are one with you
please.
that yes, reservation has to be given, but that has to be done in accordance with law.
Your Lordship, might I read this, why it will be? It is not enough to remove the formal barriers to women lawyers in contesting elections. It is the responsibility of the existing male office bearers to not only encourage female lawyers to stand for the elections, but also make the environment conducive for women to stand a fair chance. I'm optimistic that so-and-so association will take proactive measures. Your Lordship, the important area here is the fourth paragraph below that. Contesting elections requires extensive networking, campaigning, and soliciting of votes, which often leads to formation and perpetuation of an entrenched old boys club. This environment can act as a significant disincentive for the women, discouraging them from participating in the elections, let alone engaging in campaigns and successfully winning them. Your Lordship, this is the difficulty. Otherwise, both my friend and I would not even be standing here asking for it. The difficulty is...
That is why I said, if you put across this request from the side of the women advocates, I am sure appropriate decision will be taken. Otherwise,
And it will be a positive decision.
otherwise, the
This
only
representation was not given now. It was given 6 months ago, Your Lordship.
way of getting such an order is to approach the Honorable Supreme Court.
Please, Your Lordship.
This court will not be able to pass such an order.
On the 142, I will end with that, Your Lordship. The judgment that I've placed before Your Lordship.
Yes,
This is the Director of Settlements and Appara.
yes.
Your Lordship, kindly turn to paragraph 7. Paragraph 7, Your Lordship. So far as the first question is concerned, Article 141 of the Constitution unequivocally indicates that the law declared by the Supreme Court shall be binding on all courts within the territory of India. The aforesaid article empowers the Supreme Court to declare the law. It's therefore an essential function of the courts to interpret a legislation. The statements of the courts on matter other than law like facts may have no binding force, as the fact of two cases might not be similar. These are all private disputes. But here it's a different case. It's not a private dispute. So, but what is binding is the ratio of the decision and not any finding of facts.
So,
It is the
can you-
principle found out.
Can you say this is a ratio laid down by the?
No, it's the principle. That's what I'm coming to, Your Lordship. It is ultimately on the principle.
No, not possible.
Submission.
Yes.
If the Delhi High Court order, the Supreme Court order on the Delhi Association, Fawzia Rahman is with my lords.
Yes.
My lords.
There again, it's
No.
it's the Honorable Supreme Court which is
It
passing
is,
the order.
it is. But I want to just read one para. It is the Honorable Supreme Court. What the Honorable Supreme Court, in fact, by relying on the SCBA, can my lord see it in my petition, page 40? In 123, page 40. Page 40, that in para 3, page 40, my lords, para 3, not only did they implement it, they in fact said para 2 onwards. During the course of hearing, it was emphasized that restructuring of the governing bodies of the Delhi High Court Bar Association and District Bar Association of NCT of Delhi may be initiated as a pilot project, and eventually it can serve as a model to be followed on a pan-India basis, subject, however, to such modifications as may be necessitated, keeping in view prevailing local conditions. It is broadly agreed amongst all senior advocates or advocates who are present in the court that the interim arrangement made hereinafter may on an experimental basis for this year on the same analogy as was followed by this court-wide order dated 2/5 in the case SCBA. Consequently, following interim directions are issued. One post of treasurer and then 1/3. My lords, the ultimate idea of the Honorable Supreme Court is that they started with SCBA and the Delhi High Court and ultimately to follow all other bar
I am
associations.
sure it will be.
Now, if my lords are to say that we have to go to the Supreme Court and every single bar, there are hundreds of bar associations.
Not necessary. If you
every
don't want to
single
go,
association
there is
is
no
to
need
go
to
there.
go. But the Supreme Court has already commenced the process.
Yes.
But my lords, the commencement of the process over here means that the elections are now. If we lose out on this elections for another 3 years, even if the Supreme Court were to give any order, it can only come into place after 3 years.
Correct.
So for 3 years, women members of the bar, ultimately, my lords, we are equal members of the
Means
bar.
you are too late.
We are not too late. We have
6 months ago, 6 months ago, we have filed a reputation.
You should have commenced this process.
We
You should
commenced
have
it
commenced
6
this
months ago, Your Lordship.
We are
6 months ago, our representation was given. So they are stating that, no, we would have done it. It's too late. 6 months ago, representation was given. And there is only one person crying foul out there at every meeting. This is the third time, three elections prior, this issue of women's reservations been coming up.
19th court order, 20th, in fact, immediately another advocate has made the impeachment to bring it. Now, my lords, calendar of events, even if we follow it, even if we don't delay the election, by following their own bylaws, 6 days, the nominations have to be filed or whatever is the requirement. There is absolutely no difficulty. If the circular, my lord, kindly in the same
SCBA.
petition, kindly see page 33, just for a moment. Page 33 in the same, my petition.
Within 5 days, they implemented it.
On 2nd, the Supreme Court order was there at page 33. On 7/5, who has issued the circular? My friend says he's no longer the president. Very well, he may not be the president. The circular is issued by the election committee. Kindly see at the bottom. They have an election committee, or here is the returning officer or whoever is the election monitoring officer within the association. They have issued it is not the president, because the president was already outgoing, even in the SCB. So the election committee put out a circular saying that as per the reservation that by the Honorable Supreme Court. So my lord, if my lord.
Therefore, that is why I am saying again and again, such orders can be passed by the Honorable Supreme Court. Please approach the Honorable Supreme Court.
Your
get an
Lordship, if
order.
we had moved your
It is so apparent.
If we had moved your Lordship prior to Supreme Court passing the order, then maybe your Lordship could have said that your Lordship's hands are tied. But here's a situation where the Supreme Court has already passed an order, which is being implemented also by Delhi. Let us lead the way, your Lordship, by stating we are not going to wait for them. We will still, even before any directions are given and that material is collected by the amicus curiae in that matter, even before that Karnataka did it, is what we must show, your Lordship, proactive action.
If this circular is issued and if my lords were to direct that, let them provide similar reservations in one office bearer and 1/3 of others. My lords, they will easily get the nominations within the time. It is
Para 7 is a clarification for all this.
It's done within 50 elections there.
Para 7 of the order of the Supreme Court is a answer to all this. Supreme Court, first of all, says at para 3 that this is a pilot project in Delhi. That is one aspect. But at para 7, Supreme Court clearly says, we request Mr. Mridul to collect relevant information and data from all High Court Bar Associations, which is Bangalore Bar Association, which is a part of the country, and submit his suggestions after due consultation with members of the Delhi High Court Bar Association, other High Court Bar Associations, and district bar. Therefore, this is still.
That is why I said that Supreme Court has already called for such information.
And it has taken control of the entire issue.
Yes.
In such circumstances, my lord, to wade into that area, particularly under 142 jurisdiction, that would not be.
Lordship, all our
And
request
Lord,
is
we
that
are-
whatever
we
we
are
raised,
personally
even
not-
with
I'll just
respect to the provisions being contained in the bylaws itself, if that could be interpreted, and all the other issues that have been raised by both of us, that could also be observed, your Lordship.
Lord, personally, we are not against this reservation. We would want to give this reservation. But after
Your Lordship,
19th.
they're nobody to
Let me just
give it.
complete.
They don't
After
have, they're
19th.
nobody to give it. It is something that
Not
by
me.
way
It is not
of
me. The
what has
governing
been
council.
sought for, which is rightfully
Governing
theirs,
council.
have to be implemented.
Absolutely. All right. We accept Madam's plea to that extent. It is what has to be rightfully, what has to be there. That has to be there. I stand corrected. And one issue is that after 19th, clause 24 says that governing body ceases to exist. Governing body includes the present secretary, treasurer. So we cease to exist as of today. And I cannot make any statement either this way or that way, but I'm for it. Personally, I'm for it and we have to give this.
This is under the Karnataka Society Registration Act.
Registration Act.
Correct.
Section, clause 24 of the bylaws. Of our bylaws.
He's talking about the society's registration.
Karnataka Society Registration Act.
Illa, societies. 24 ನಲ್ಲಿ blood we cease to exist ಅಂತ ಇದೆ.
ಅದಲ್ಲ. There is a provision for amending the bylaws.
The method of.
There is a procedure prescribed.
Yes.
So you have to follow that.
We have to follow.
Huh? Not necessary. That is why I'm saying the act itself
Act
provides.
provides.
There is no need for the bylaw to say it can be amended. The act itself says, yes, it can be amended.
And there is
But
also
you will have to follow the procedure.
procedure.
A request has to be made by the requisite number of members.
Yes.
And it has to be placed before the august body.
General body.
General body.
Passed by
and
majority.
By majority, it has to be accepted.
Yes.
Only then the amendment can take place.
And then incorporate.
And courts cannot issue such directions, divorce any such provision in the bylaws. The Supreme Court will simply find fault with the court.
Yes.
If I were to issue such a direction.
Yes.
It is not possible.
We are only seeking that the Supreme Court directions be followed by them.
Supreme Court directions is not in respect of our bar association.
Yes.
Ultimately, it is to
That is why the Supreme Court has already commenced that process. It has called for information, and I'm sure some orders will be passed by the Supreme Court. But then till then we'll have to wait. But these elections cannot be,
No, elections need not even be delayed, Your Lordship. The second argument is that if similar to Delhi High Court postponing, if that cannot be done, even the elections are to be held on the 2nd. This still could be implemented by the committee.
Yes, we are well with
The High Power Committee is anyway existing. And the High Power Committee, Your Lordship, in so many other matters, conveniently the bylaws have been overlooked. They have made enough modifications. Like I mentioned yesterday, Your Lordship, the rules have been modified conveniently where it was only 15,000 rupees to be paid. Now it is 1 lakh to be paid by the president.
That is all amended, my lords. That is not correct.
Last time.
Not fair to make
That is the
allegations
previous
against
term
High
of,
Power Committee.
governing
High
council
Power
is
Committee
amended. We have not amended
ತಗೊಂಡಿರೋದೇ very responsible advocates are there in the High Power
Please
Committee.
kindly look
Not
at
fair, my lords.
33F.
please see section 9. 9 of the act says,
Please.
whenever
Please
it shall appear to the governing body of any society registered under this act, which has been established for any particular purpose or purposes, that it is advisable to alter, extend or abridge such purpose or for any other purposes specified in section 3, the governing body may submit the proposition to the members of the society in a written or printed report and may convene a special general body meeting for the consideration thereof according to the rules and regulations of the society.
Please.
So they have to follow all this procedure and then bring in an amendment, make a provision for reservation.
Registrar should incorporate it.
And everyone will be bound by that. If there is a provision enabling reservation, even the High Power Committee will be bound by that.
the High Power Committee itself can in fact.
Now
issue
it
these
cannot do it, neither they can
There is
do
no
it
power in the
nor
bylaw.
can this court do it. It will be a direction issued contrary to the bylaws, which would be impermissible.
Impermissible. Totally.
Your Lords, in this matter before this honorable court itself,
The
this
calendar of
was in
events.
April 2022. Your Lordship, all of these changes were made without amendments. Executive Committee to immediately stipulate a prescribed format, application for purpose of transfer ownership.
If you wanted to raise a challenge to that, it was available to you.
Your Lordship.
Just because there were certain
Collateral
acts and omissions done contrary to the bylaws, that cannot be said to enable this court to issue the same directions.
Your Lordship.
No, you do it contrary to your bylaws.
It's
or
not about
provisions.
contrary, Your Lordship. It's
That was
ultimately
there.
it's been done earlier.
That was
We are
there in
always
the
saying
old term.
what's good for the goose should be good for the gander. But of course, here is the reverse.
calendar of
What's good for
events.
the gander should be good for the goose here, Your Lordship. We're stating that if they have been able to manipulate and not utilize and amend the bylaws and still have changes made by this honorable
Right to
court,
say manipulate.
same could be done for a social cause, Your Lordship, not for any private interest, where here all of this is private interest.
My lord, and only one submission, all for every implementation of any act, amendment is not required. Amendment also for any provision or any action to be done. Amendment is not
Clauses Act.
mandatory. My submission.
What about
is
General Clauses Act?
Providing reservation
The
or reserving a certain
Should be by
post.
a law. Should be by a law.
Can
There
it
is-
can
there
it be
is-
done without a
still-
provision of law?
No, my lords, there is no such restriction either in the Societies Registration Act or in their bylaws that it has to be only by an amendment. In fact, that is why the Honorable Supreme Court said that even in their association, in the other association, if they've not done it also, we will,
Read it yesterday also. In fact, there was a proposal put up,
which was
but it
rejected.
could not be carried out because there was lack of majority.
Yes.
In those circumstances, the Supreme Court has issued the directions.
With,
dehorse all that.
in fact, it is
Now called for information from all the bar associations of the country.
in fact, the Honorable
Supreme Court may as well pass an order.
But my lords, the aim of with great respect, we are in my lord's hands. But the aim of the Supreme Court is not that every association or every state we should pass orders. We are laying down a blueprint. The aim of the Supreme Court is we are laying down a blueprint to ensure that this is done in all associations. Here we have an opportunity to do it within the time frame. We have an opportunity. My lords, if we lose the opportunity for 3 years, then my lords, we are in fact not following what the Supreme Court intended.
No, even now you have that opportunity. Please go before the Honorable Supreme Court, file an application, get an order.
Your Lordship, may kindly see just my paragraph on the top. Your Lordship may kindly see bylaw 33D, existing time period 3 months. What has it been reduced to 1 month? 33E 7 days, 33F 15 days. And reduced cutoff period, it has all been modified, Your Lordship, by
That has
by
been
way
gone
of
into
improvement at that point of time.
In the
And if
previous
Your Lordship,
year.
Supreme Court has directed, get the data and all of that. Lordship, one is data with respect to each court. For example, Andhra Pradesh already has a provision where lady member. So that is why data is being collected wherein if some state has already implemented it, it might not be required. If some state still has elections in not round the corner, but a year or two later, then what? We are at a situation where we would be able to implement it immediately and beat them all to it and show that we as Karnataka, we are progressive enough that we would be able to implement it even before we direct it to.
There is an intent, but there is difficulty.
Your Lordship, then.
That's why I said yesterday, I am sure all the learned members of the bar would accept your suggestion.
6 months ago,
But there are certain difficulties.
6 months ago,
At this stage,
We are in complete consensus that it has to be.
Absolutely, my lords.
It
We
has
are
to
all-
be there. Reservations.
I
have to
don't
be
think anyone would oppose this kind of a proposal.
It cannot.
Your Lordship, they cannot oppose because.
No, that is why I said this should have been taken up at least 1 year earlier
Yes.
to enable the amendment to be brought to the bylaws.
There were many, ultimately the only thing that has come now for rescue is the Supreme Court order.
And that is why everybody is moving, Your Lordship, because of the applications represented earlier, it is not just the petitioner. 3 others have already submitted their representations. That all goes into cold storage. Your Lordship, it might all seem very well that, oh, we are for it. Your Lordship, ultimately, they have to walk the talk. If they are for it, then they must show it. They are not willing to. If 6 months ago, there was a representation and it has not been acted upon, they have not discussed it in their meetings, then it just shows.
Madam Lakshmi Angara had told me, it is there, I would have moved it 6 months ago. Madam didn't inform me. The leaders of the bar should take some interest.
File petition, Your Lordship.
Leaders of the bar should take
I'll
interest.
pass orders at 2:30.
Please,
But the
obliged,
calendar of
obliged.
events, sir.
We'll continue at 2:30.
Please,
Pass orders.
please, please.
So when you consider the answers, ಕೊಡ್ತೀನಿ ಸರ್ ನಾನು ಇದು ಕೈಯಿಂದ ಬರ್ಕೊಡ್ತೀವಿ ಯಾವ್ದಾದ್ರು ಕನೆಕ್ಟ್ ಆಗ್ತಿಲ್ಲ ಮೇನ್ ಕೇಸ್ ಇಲ್ಲ ಯಾವ್ದು ಕನೆಕ್ಟ್ ಆಗಿಲ್ಲ ಸೇಮ್ ರಿಲೀಫ್ ಹಾ
Dispose ಆಗಿದೆ ನವೆಂಬರ್ 4 ಮಾತ್ರ ಥ್ಯಾಂಕ್ ಯು
ಆಫೀಸ್ ಆಫ್ ದಿಸ್
ಈಗ ನೋಡ್ತಾನೆ ಇದ್ರಲ್ಲ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಅದನ್ನ ಕೇಳ್ತಾ ಇದ್ದೀರ ಅದನ್ನ ಬಂದು ನೋಡಿ ಇನ್ನೂ ಇದೆ ಇದೆ ಬನ್ನಿ.
ನಮಸ್ಕಾರ ಸರ್ ಈಗ ಬರ್ತಾ ಇಲ್ಲ ಬೋರ್ಡ್ಗೆ ಕಳಿಸಿದ್ದಾರೆ ನೀವು ಕೋರ್ಟ್ ಆಳಿಗೆ ಹೋಗಿ ಕೊಡ್ತಾರೆ ಸರ್ ಬರ್ತೆ ಫೈಲ್ ಬರ್ತೆ ಅಂತ ಹೇಳಿದ್ರು ಬಂದಿದ್ದೀನಿ ಈಗ ನನಗೆ ಬಂದಿದೆಯಾ ಗೊತ್ತಾಯ್ತು ಗೊತ್ತಿಲ್ಲ ಸರ್ ವೋಟಿಂಗ್ ಸರ್ವ್ ಮಾಡಿದ್ದೀನಿ ಪಾರ್ಟಿ ಮಾಡಿದ್ದೀನಿ ಅದು ಕೋರ್ಟ್ ಮೂಲಕ ಕಳಿಸೋದಕ್ಕೂ ಎಲ್ಲ ಸಬ್ಮಿಟ್ ಮಾಡಿದ್ದೀನಿ ಪ್ರೊಸೆಸ್ ಫೀ ಕಟ್ಟಿದ್ದೀನಿ ನಾಳೆ ನಾನು ಮೂವ್ ಮಾಡ್ಬೋದಾ ಮೆಮೋನ ಅಕ್ಲೈನ್ಮೆಂಟ್ ಇಲ್ಲ ತಂದಿದ್ದೀನಿ
ಅದು ಡೇಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಡೇಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಡೇಟ್
ಡೇಟ್ ಕೊಟ್ಟಿಲ್ಲ
ಮಾಡಿದ್ದೀರಾ
ಹಾಂ ಅಕ್ಲೈನ್ಮೆಂಟು ಇದೆ
ಸರ್ ಅವ್ರು ಬಂದ್ರೆ ಅವ್ರ ಹತ್ರ ಕೇಳ್ಬೋದಾ ಅಟ್ಲೀಸ್ಟ್
ಗೊತ್ತಿಲ್ಲ ಸರ್ ನೀವು ಯಾರೋ
ಅವ್ರು ಇಲ್ಲ ಸರ್ ಐ ವೆಂಟ್ ಟು ಸ್ಕ್ರೂಟಿನಿ ಫ್ರಮ್ ದೇರ್ ಐ ಆಮ್ ಕಮಿಂಗ್ Okay, I'm at dark still. Let me see.
one mention, my lord. My lord, one moving memo in this matter, the interim matter has to be extended tomorrow, my lord.
Tomorrow morning, not now. Yes.
Tomorrow morning. ನಾಳೆ ಬೆಳಿಗ್ಗೆ move ಮಾಡಿ. Morning. The pronouncement of orders at 2:30 PM. Serial number 74.
No, no.
Vijay Singh M.
The respondent.
Consequently, the review petition is dismissed, imposing costs of rupees 25,000 on the review petitioners. The cost shall be payable to the Karnataka Advocates Welfare Fund within a period of 4 weeks from the date of receipt of a certified copy of this order. Ordered accordingly.
Serial number 75. Dalwai Venkatesh.
Having regard to such peculiar facts and circumstances, and having regard to the law laid down by the Honorable Division Bench in the case of Digambar Bharti, this court proceeds to pass the following order. The writ petition is partly allowed. The impugned order dated 28/2/2019, passed by the learned senior civil judge and JMFC Dodbalapura in OS number so and so, though upheld. Nevertheless, 3 months' time is hereby granted to the petitioner, plaintiff, to pay the deficit stamp duty and penalty as determined by the trial court. On receipt of such deficit stamp duty and penalty, the trial court shall reopen the case and forward the original memorandum of agreement dated 8/8/2009 along with the deficit stamp duty and penalty to the district registrar bar deputy commissioner concerned. The district registrar, deputy commissioner concerned shall hear the petitioner, plaintiff, in terms of subsection 2 of section 37 of the Act and determine the penalty payable, which may be ₹5, or if he thinks fit, an amount not exceeding 10 times the amount of proper duty or of the deficit portion thereof. The officer shall pass orders accordingly and while retaining the deficit stamp duty or determined stamp duty and penalty, he shall return the remaining to the petitioner, plaintiff. After completion of the entire process, the trial court may proceed from the stage immediately before the passing of the impugned order dated 28/2/2019, ordered accordingly.
Grateful, my lord.
Serial number 76, Shiv Kumar.
For the reasons stated above, this court is of the considered opinion that there is no merit in the writ petition. The writ petition is accordingly dismissed.
Continuation.
Yes.
Serial number 31.
My lords, I may just kindly be excused. I have another matter, since my lords are dictating.
All right. Senior counsel Nalina Mayagowda is here.
She said that she'd probably await, and if this gets listed, then probably tomorrow, then expect the same order to be.
Petition is not.
Huh?
It was filed, but it is not listed.
Gotayitu. No, in fact, she sought to move it in the morning. I said that it cannot be taken up now. I thought if she is available here, if she wants to make submissions, she can make. Idara? Huh? Online.
I'll ask her to connect.
Illa bidi, it's okay, it's all right. Let that matter be listed, then we will hear. ಇದು ಈ ಎರಡು ರಿಪಿಟೇಷನ್ ಮಾತ್ರ ಬೆಳಿಗ್ಗೆ ನಾನು ಮೆನ್ಷನ್ ಮಾಡಿದ್ನಲ್ಲ 31.2 and 31.3 ಈ ಎರಡು ರಿಪಿಟೇಷನ್ ಮಾತ್ರ.
Let's one submission. My IA is also.
I will say that, I'll say that. After this writ petitions are disposed of,
Please,
I'll pass orders in respect of your application.
please, ma'am, please.
It is only an application for impleadment.
Please.
Ashte.
Ashte, but for the same reason. ma'am.
For the same reason, all right. Both these writ petitions raise a common ground. Directions to the sixth respondent, Advocates Association, Bengaluru, and the high-powered committee which was constituted by this court for the purpose of conducting elections to the sixth respondent association, for providing reservation for the women advocates and members of the association in the governing council and the executive committee of the association. Full stop. Therefore, both these writ petitions were clubbed, heard together, and are being disposed of by this common order. Next para. Learned senior counsels, Srimati Lakshmi Iyengar and Srimati Jaina Kothari, have made submissions on behalf of the petitioners. Full stop. Essentially, having regard to directions issued by the Honorable Supreme Court in the case of Fauzia Rahman versus Bar Council of Delhi and another in special leave to appeal, bracket C, numbers 24485 of 2024. Dated 19/12/2024. Where is the other one?
Which one?
And Supreme Court Bar Association versus vide Kaushik. in miscellaneous application, diary numbers 13992 of 2023. Dated 2/5/2024. The learned senior counsels submit that the Honorable Supreme Court has thought it fit to issue directions in both those cases to provide reservation for women members of the bar. Full stop. Learned senior counsels submit that in the case of the Delhi Bar Council, which was that case where the elections were underway?
Please, this.
Please give it. Which arose from petition bracket C 10363 of 2021 from the High Court of Delhi. The Delhi High Court thought it fit to adjourn, postpone the elections that were due to the Delhi High Court Bar Association, where similar plea were raised for providing reservation to the women lawyers in the posts of the office bearers of the association. Full stop. Consequently, directions were issued by the Honorable Supreme Court. In which one?
In Fawzia, Your Lordship, that is at page 74.
In Fawzia Rahman, Bractal Supra.
'80 and 81 page.
To provide reservation to one post of treasurer exclusively for women candidates, semicolon, one post of the members of the executive committee who are to be elected from amongst the senior designated advocates semicolon. One post of executive member in the category of advocates having 25 years of practice, etc. It was pointed out that as the facts obtained in the present scenario, where directions have been issued by this court in the connected writ petitions for conducting the election to the Bar Association, similarly, in the case of Delhi, also the elections were due and underway. Stop. Nevertheless, both the High Court of Delhi as well as the Supreme Court thought it fit to issue directions to enable the elections to be held while providing reservation to the women advocates and members of the association. Full stop. Therefore, both the learned senior counsels submit that although a time frame has been fixed by this court in the connected writ petitions to hold elections to the Advocates Association, Bengaluru, nevertheless, it would not preclude this court from issuing necessary directions, as was done in the case of the Delhi Bar Association. Full stop. Next para. Per contra, learned senior counsel, Shri Vivek Reddy, appearing for the association, submitted that the orders and directions issued by the Honorable Supreme Court would stem from Article 142 of the Constitution of India, and such directions cannot be issued by this court. Full stop. It is submitted that unless the bylaws provide for such reservation, directions cannot be issued to the association or the election officer to provide reservation to the women advocate members of the association. Full stop. Learned senior counsel would submit that the term of the present managing committee and the governing council has come to an end on
19 December
2024, and when the term of the previous committee and governing council has come to an end, no statement can be made on behalf of the association to provide such reservation to the women advocates in the ensuing elections. Full stop. The learned senior counsel would fairly submit, that though he was the president of the association till the term ended on 19th of December 2024, at present, since the term of the committee has come to an end, comma, he will not be able to make any statement acceding to the submission made by the learned senior counsels. Comma, although personally he would be willing and welcoming such a request made by the women advocates and members of the bar association. Full stop. The learned senior counsel would submit that taking the request made by the women advocates and members of the association forward, comma, immediately after the elections are held, comma, such a proposal will be put forth in the association and suitable amendment will be sought to the bylaws of the association, enabling reservation to certain posts in the managing committee and the governing council. Full stop. However, at this stage, comma, when there is no such provision for reservation in the bylaws of the association, comma, neither can the petitioners seek such directions at the hands of this court, nor can the association make any such concession before this court to provide reservation to any of the posts in the ensuing election. Full stop. Next para. Having heard the learned senior counsels for the petitioners, comma, the learned senior counsel for the respondent, Advocates Association, comma, Bengaluru, and on perusing the petition papers, comma, this court is of the considered opinion that the directions issued by the Honorable Supreme Court in the decisions cited by the learned senior counsels appearing for the petitioners, comma, are directions issued under Article 142 of the Constitution of India. Full stop. Such powers cannot be exercised by this court. Full stop. Moreover, this court finds that the Honorable Supreme Court has already commenced the process of calling for relevant information and data from all the high courts, bar associations of the country in order to issue suitable directions enabling reservation of certain posts to the women members of various bar associations in the country. Full stop. The submission made by the learned senior counsels for the petitioners that in the case of the Delhi Bar Association, the Delhi High Court postponed the holding of elections, and therefore this court also should issue such directions postponing the elections, comma, cannot be accepted, comma, for the simple reason that in the case of the Delhi Bar Association, comma, when the writ petitions were pending before the High Court of Delhi, comma, SLPs were filed before the Honorable Supreme Court, and the Supreme Court had issued certain interim directions. Full stop. That is not the scenario in the present case. Full stop. During the course of the proceedings in the connected writ petitions, certain directions were issued by this court, and accordingly, comma, it is submitted at the bar that the calendar of events have been issued on 2nd of January 2025. Allah, he is saying it was issued on 2nd itself.
ಇಲ್ಲ voters list, finalize voter list. Calendar of events issue ಆಗಿಲ್ಲ.
The final voters list were published on 2nd of January 2025.
By the high power committee.
Calendar of events have been issued today.
I'm sorry.
Full stop. It was therefore submitted that the code of conduct has come into operation from 2nd of January 2025. And having regard to the settled position of law as declared in Ponnuswamy versus state, no courts can pass any orders which would cause any interference in the process of election. Full stop. It is also a settled position of law that such a law declared by the Honorable Supreme Court is also applicable to elections held to societies and associations. Full stop. Under such circumstances, it would be impermissible for this court to issue any such direction to the election officer or the high power committee which has been installed by this court for the purpose of conducting elections to the Advocates Association, Bengaluru, to provide reservation to certain posts in the managing committee or the governing council, without there being any such provision in the bylaws. Full stop. Next para. On the other hand, it may be open for the petitioners to approach the Honorable Supreme Court and seek necessary directions, since the Honorable Supreme Court in its order dated 19/12/2024 in Fauzia Rahman Supra has already initiated action to collect the relevant information and data from all the high courts, bar associations of the country
by the amicus curiae. Paragraph 6, my lords, amicus curiae appoint ಮಾಡಿದ್ದಾರೆ.
6, 7 and 8.
for the purpose of considering as to whether such directions could be issued to all the bar associations in the country. Full stop. The elections are required to be held to the respondent association on yavattu
2nd February.
2nd of February 2025, in terms of the directions issued by this court. Full stop. Therefore, at this juncture, the request and submission made on behalf of the petitioners cannot be accepted or conceded. Full stop. Next para. With these observations, the writ petitions are dismissed. Full stop. ಇವಾಗ ಇನ್ನೊಂದರಲ್ಲಿ
That's a main matter. The main matter ಅಲ್ಲಿ
This is
ಹಾಕಿದ್ದು
in 30, Your Lordship. In the main matter, she's filed an impleading.
ಕೊಡ್ರಿ ಅದು 33121 ಅಲ್ಲಿ
34305.
IA number 1 of 2025.
ಅಲ್ಲ 31 ಅಲ್ಲಿ 31 34305.
31 ಅಲ್ಲಿ ಇದೆ ಮತ್ತೆ 31.1 ಅಲ್ಲೂ ಇದೆ ಅಲ್ವಾ?
31.1 ಇನ್ಫ್ರಾಕ್ಷನ್ಸ್ ಆಗಿದೆ ಅದು ಡೈರೆಕ್ಷನ್ಸ್ ಇಶ್ಯೂ ಆಗ್ಬಿಟ್ಟಿದೆ BEL ಗೆ ಮತ್ತೆ ಎಲೆಕ್ಷನ್ ಕಮಿಷನ್ ಇಂದ.
So it's
ಅದು
only in
31.
34305,
ಹೌದು.
Order on IA number 1 of 2025. WP 34305 of 2025 ಅಲ್ಲಿ. This application is filed by the intervening applicant seeking to come on record as a party respondent to the proceedings. ಎಲ್ಲಿ ಯಾವ ಪ್ಯಾರಾಗ್ರಾಫ್ ಅಲ್ಲಿ ಹೇಳಿದಿರಮ್ಮ?
What's the let's from second parameters. Para 2.
ರಿಸರ್ವೇಶನ್ ಬಗ್ಗೆ.
Reservation ಬಗ್ಗೆ it's para 2 ಇಂದ ಸ್ಟಾರ್ಟ್ ಆಗುತ್ತೆ. I state that we are practicing advocates having membership of the Bengaluru Bar Association.
ಎಲ್ಲಿ ಯಾವ್ದು ಓದ್ತಾ ಇದೀರ ನೀವು?
Para 2, affidavit minutes. Completing application ಗೆ affidavit is para 2 of the affidavit minutes. This is IA number 2 of 24.
IA number 2 of 24 ಅಲ್ಲ, 1 of 25 ಅಲ್ವಾ?
ಇಲ್ಲ 25 ಹಾಕಿಲ್ಲ ನಾನು. Before vacation started I filed minutes.
What is 1 of 2025? That is also an impleading application filed by you only. For what purpose?
That is this process is that this petition is not going to survive because
ಅಲ್ಲ ಅದು ಇಂಪ್ಲೀಡಿಂಗ್ ಅಪ್ಲಿಕೇಶನ್ ಅಲೋ ಮಾಡ್ಬೋದು ಅದರಲ್ಲಿ. ಲೆಟ್ ಹಿಮ್ ಕಮ್ ಆನ್ ರೆಕಾರ್ಡ್ ಅಷ್ಟೇ. ಅದು 1 of 25. He will come on record and assist.
2 of 2024. ಏನ್ ಹೇಳಿದೆ? To seek certain directions. More particularly, to provide 33% reservation in the upcoming elections to the managing committee and governing council of the Advocates Association, Bengaluru. Full stop. Next para. This court has today considered 2 writ petitions which were filed seeking similar reliefs and directions regarding reservation to be provided to the women members of the Advocates Association Bengaluru, and has dismissed the writ petitions. Full stop. Therefore, in terms of the orders passed in the 2 writ petitions, this application also stands dismissed.
Another application is there, Manager. Today has put up that another application filed on 2012
Same. ಯಾವ್ದ್ರಲ್ಲಿ? 34305. ಹಂಗಾರೆ ಅದನ್ನ ಹಾಕೊಂಬಿಡಿ. Yes. 31. ಆಯ್ತು, directions have been issued.
Does not survive. But those directions should be made absolute.
ಕೊಡಿ ಅದು 33121 ಅಂದ್ರೆ ಡೈರೆಕ್ಷನ್ಸ್ ಅದರಲ್ಲೇ ಪಾಸ್ ಮಾಡಿದ್ರ ಅಥವಾ ಇನ್ ದಿ ಕನೆಕ್ಟೆಡ್ ರಿಪಿಟೇಷನ್ ಆರ್ಡರ್ ಶೀಟ್ ಕೊಡಿ.
These directions are by way of interim direction. They must be made absolute. Thank you.
ಇಲ್ಲಪ್ಪ ಇದ್ರಲ್ಲಿ ಮಾಡಿಲ್ಲ.
Commonly.
ಅದ್ರಲ್ಲಿ ಇರ್ಬೇಕು ನೋಡಿ. ಅಲ್ರಿ ಆರ್ಡರ್ ಶೀಟ್ ಕೊಡ್ರಿ. ಆ ಫಸ್ಟ್ ಮ್ಯಾಟರ್ 34305 ಆರ್ಡರ್ ಶೀಟ್ ಕೊಡ್ರಿ.
ಇಲ್ಲ.
18/12/2024 ಆರ್ಡರ್ ಅಲ್ಲಿ ಎಲೆಕ್ಟ್ರಾನಿಕ್ ವೋಟಿಂಗ್ ಮಿಷನ್ ವಿಲ್ ಬಿ ಪ್ರೊವೈಡೆಡ್ ಅಂತ ನೋಟ್ ಮಾಡಿದ್ದಾರೆ. 18/12/2024. That is already noted. ವೈಶಾಲಿ ಹೆಗಡೆ ಸಬ್ಮಿಷನ್ ರೆಕಾರ್ಡ್ ಮಾಡಿದ್ದಾರೆ.
ಅದು ರಿಪಿಟೇಷನ್ ಕೊಡಿ 33121. ಬರ್ಕೊಳ್ಳಿ. This writ petition is filed by learned senior counsel Shri Vivek Subbareddy, seeking a writ of mandamus, to direct respondents number 1 and 2 to provide electronic voting machines, bracketly EVMs, and to depute personnel for the smooth and transparent polling and counting process of election, which is due to be held to the Advocates Association, Bengaluru. Full stop. Next para. The learned senior counsel and the learned AGA point out to order dated 18/12/2024, whereby the submission made by Srimati Vaishali Hegde, learned counsel representing the Karnataka State Election Commission, was recorded to the effect that electronic voting machines will be made available to the association to hold the elections, subject to the condition of availability of the EVMs and no other elections being scheduled on the day where elections are required to be held to the association.
So far as police commissioner paragraph number 8, my lords. ಅದು ಡೈರೆಕ್ಷನ್ ಇಶ್ಯೂ ಆಗಿದೆ. ಪ್ಯಾರಾ 8.
ಪ್ಯಾರಾ
8 ಕಮಿಷನರ್ ಆಫ್ ಪೊಲೀಸ್ ಅಂತ ರೆಕಾರ್ಡ್ ಆಗಿದೆ. ಡೈರೆಕ್ಷನ್ ಇಶ್ಯೂ ಆಗಿದೆ.
Further, in the order dated 20/12/2024, directions have been issued to the Commissioner of Police, Bengaluru, to ensure adequate bandobast and security during the elections to be held to the association. Full stop. The High Power Committee was also authorized to issue necessary guidelines to facilitate the smooth conduct of the elections. Full stop. In that view of the matter, learned AGA would submit that the directions issued by this court may be made absolute and the writ petition may be disposed of. Full stop. Next para, learned senior counsel, Shri Vivek Subbareddy, who is also the petitioner in the writ petition, accepts the submission made by the learned AGA and submits that such directions may be issued and the writ petition may be disposed of. Full stop. Next para. Accordingly, the directions issued by this court on 18/12/2024 and 20/12/2024 regarding providing of the EVMs to the elections which are scheduled to be held on 2nd of February 2025
And provision of police.
and the provision of police personnel during the elections are hereby made absolute and the said authorities are directed to ensure and comply the directions issued by this court regarding provision of the EVMs and the police personnel. Full stop. Ordered according. The writ petition is accordingly disposed.
Gratefully.
Grateful.
Right.
Lower matter. Number 16. Bill number 16.
Parole. Huh? Huh?
Yesterday, my lord, yesterday also he was in the, day before yesterday, he was in the Chikmagalur Central Jail. That's why, my lord, now they are saying that Shumaga Jail. Even till today, they are not taken any parole. Because of this is, my lord, on 4/12/2024, he surrendered. Within a span of 24 days, his mother died. Question of taking parole doesn't arise, my lord. Because 6 months is required for taking a parole.
Surrendered.
Surrendered, because kindly see, my lord, he convicted for the offence of 324. Against that order, I filed an appeal before this Honorable High Court. This Honorable High Court confirmed the order of the trial court. And as per the confirmation of order, I voluntarily, the petitioner father surrendered before the court for serve the sentence on 4/12/2024. And 31/12/2024, so mother died. That's why, my lord, we gave a representation to the
the division bench
order September 2024 is a partial order, confirm the order of the
20th of September 2024.
Yes, madam. And December, the December.
That was an appeal filed by the state.
One second appeal, my lord, kindly see. Next page, page number 14. 1946 of 2024, 2019. Second accused, Sri Nagabhushan. He's an accused. He was on bail and he surrendered on 4/12/2024. And 31/12/2024, his mother died. Immediately we approached the central prison, but they are not allowed. And hence we filed a writ petition on 4th because the righteous started today, my lord. He has to, within 14 days, we have to, on that day, first date of cremation is not available. And the 8th day it will start. And up to 14th day, normal cremation and other righteousness. He's a only son. He has to attend.
Similar suggestion, my lord, this honorable High Court permitted the, permitted and attend the 30 days, the parole period has been granted. ಎಲ್ಲಿ ಅದೆಲ್ಲ ಅವಾಗಲೇ ಕೊಟ್ರಲ್ಲ ಎಲ್ಲದು ವೆರಿ ದಟ್ ಕೊಟ್ಟಿದ್ದೀನಿ ಅವಾಗ ಕೊಟ್ರಲ್ರಿ ಯಾವಾಗಲೇ ಎಲ್ಲ ಇದೆ ಇದರಲ್ಲೇ ಇಟ್ಟಿದ್ನಲ್ಲ ಹಾ ಇಲ್ಲಿದೆ para 4 mal was also convicted learned counsel for the petitioner seeks to place reliance on a decision of the coordinate bench of this court in WP number 25100 of 2023, dated 15th of November 2023. Full stop. Learned counsel submits that under similar circumstances, this court allowed the writ petition to enable the petitioner to attend the obsequious ceremony of his father. ಅಲ್ಲ ಇದರಲ್ಲಿ and directed the respondent authorities to consider the representation of the petitioner and release the petitioner on emergency parole for 30 days. We'll stop. Next para. However, this court finds that in the said case, the coordinate bench found that the petitioner had not sought for parole earlier and he had completed a total sentence of 13 years, 2 months and 22 days, comma, including remission. Full stop. Therefore, comma, this court had called upon the learned AGA to secure instructions as to whether the petitioner had earlier sought for parole. Full stop. On instructions, the learned AGA would submit that the petitioner who was earlier lodged in Chikmagalur jail has since been shifted to Shimoga jail and he was not able to get the information. Full stop. Next para. Release this matter. My petition will be infructuous, my lord, because I am not able to attend my ಯಾವತ್ರಿ ಇರೋದು ಅದು 8th day ಇಂದ 14th day day by day ಒಂದೊಂದು rituals ಇರುತ್ತೆ. So that it is started today. And it started today it is lapsed. That's why, my lord, my sincere submission, my lord, I produced the honorable High Court order also. And also, my lord, I voluntarily surrendered before on 4/12. And remaining 3 months is the jail sentence, not life sentence. It's only 1 year sentence. And he already served the sentence in 9 months. Well, if it's a lifetime, it's only once. It's a mother Rachel's is concerned. He can't able that one in future. That is the reason, my lord, it's urgency. See, that is why I said that order was passed by the division bench on 20th of September 2024. Yes, my lord. And you said you voluntarily surrendered when? 4/12. 412.
412.
What were you doing for?
Because I want
3
to,
months.
I get a certified copy. I get a certified copy. Whether kindly see, my lord, my one year sentence. That's all. Not a life sentence.
You had to immediately surrender after the order was passed by the
Yes, my
division
lord,
bench.
after obtaining
What were you doing for 3 months?
after obtaining a certified copy, and I taken an opinion from the Supreme Court whether I have to approach
Matter on 10th of January.
say infectious, my lord.
Why it
Tomorrow,
become infectious?
because if it is the day, and I have to do 8th, 9th and 10th day and 12, 13 days. It's the most important in lifetime.
We will see. Yes.
Day
Day after tomorrow.
Tomorrow, my lord, sir, because tomorrow, at least, my lord, it's a lifetime once it will come. That's why.
ನಾಡಿದ್ ಬೆಳಿಗ್ಗೆ ಬರುತ್ತ್ರಿ.
ಅಲ್ಲ ನಾಳೆ ಬೆಳಿಗ್ಗೆ ಬಂದ್ರೆ ಈಗ ನಮ್ಮ ಇದ್ರಲ್ಲಿ ಪಿಂಡ ಪ್ರದಾನ ಅಂತ ಇರುತ್ತೆ. ಪಿಂಡ ಪ್ರದಾನ ಲಾರ್ಡ್ ಇಸ್ 8th day and the 9th day is some other ceremony, and it's the only son. That is the reason, my lord, it's urgency I am saying.
Yes, yes.
Tomorrow, my lord.
ನಾಳೆ ಆಗುತ್ತೇನ್ರಿ? ಹಾ? ಆಯ್ತು. Tomorrow.
Please.
Yes.
One submission.
Huh?
The order copy could be released, your lordship. Or uploaded it.
ಮಾಡೋಣ. We will do it as fast. ಮಾಡೋಣ. We will do it as fast as possible. Yes.
ಈಗ ಎಲ್ಲರಿಗೂ ವುಮೆನ್ ಪವರ್ ಬಂದಿದೆ.
ಅಲ್ಲ
They are fighting
this
for-
process should have commenced a year ago.
Yes.
At least.
ಅಲ್ಲ ಬಟ್ ನಾನೇ ಕಮಿಟಿ ಮೆಂಬರ್ ಆಗಿದ್ದಾಗ ಒಂದು 4 ಟರ್ಮ್ ಇಂದ ನಾನು ಹೇಳ್ತಾ ಇದ್ದೆ. That's the
ಆಯ್ತು.
Yes.
Okay, for petitioner.
Lord, I have filed wakalat for the respondent number 4, and the petitioner has got alternative remedy of filing appeal before the DRT. Therefore, the writ petition does not survive.
But the petitioner is neither the borrower nor the surety. my lord. Petitioner is the first daughter. It is the father's property, my lord.
He has executed the mortgage deed, my lord.
My
earlier.
lord, the petitioner has not executed any mortgage, my lord. Kindly
Please,
refer to
my
the
lord,
3
we have
mortgages, my
issued
lord.
possession notice,
My lord, I would,
and symbolic possession notice was issued. That is being challenged before this honorable court, annexure H1 and H2. And
But
he has
I would
to
just-
challenge it before the DRT.
my lord, I just would like to draw your lordship's attention to the 3 mortgages, my lord. The petitioner is not the party to the mortgage at all, my lord.
Then who are you?
My lord, I am the daughter, my lord.
Huh?
This is, the petitioner is the daughter, my lord. The father had executed a GPA ಅಂತ ಹೇಳ್ತಾರೆ in the first mortgage, my lord.
Ah.
Kindly have a look at the first mortgage, my lord, in page 61, my lord. My lord, in the last sentence, they say the executor number 1 being the private limited company of the executor number 2 and 3
And
are the directors.
you are not entitled to go before the DRT?
My lord, my main objection is with regard to the 13-4 notice, my lord. That notice is also not served on me, my lord.
Why it should be served on you? Who are you?
My lord, I am also.
That is your contention.
My lord, my
Go
father,
before the DRT.
my lord, my father is no more, my lord. My lord, he expired in 2015 itself, my lord. I am a legal heir, my lord. And I have an equal share in the property.
You are
Kindly
appearing
refer
for the
to,
bank, is it?
my lord, kindly refer to the 2 mortgages, my lord.
Outstanding amount is
Matter of
more
the
than
service of
4
notice
crores.
on response number 1 to 3.
My lord, there is an interim order, my lord, interim order,
Air interim order.
not to precipitate any action on the notice, my lord. No precipitative steps to be taken by the respondent number 4 on the scheduled property, my lord. There are 3,
Yes, my lord.
there are 3
this person-
properties, my lord.
The petitioner has all
3 properties. Mine is only 1 property what I have filed this writ petition, my lord. Only against this property I am
But if the
seeking, my lord.
property is mortgaged, where you will get a separate right to canvass all these things?
My lord, I will just point out.
Father has mortgaged the property.
No,
to
my
the
lord,
bank.
he has not, my lord, he has not, my lord. That is the contention. My lord, there is a fraud played, my lord. The GPA, the GPA that they're referring to is a Xerox copy of the GPA on which the
ಇದು,
sanction is granted, my lord.
DRT Act ಮತ್ತೆ DRT Act ಮತ್ತೆ ಇದು ಸರ್ಫೇಸ್ ಆಕ್ಟ್ ಎರಡು ಕೊಟ್ಟು. Which is the provision which
section 17, ma'am.
enables even a third party to.
Section
oppose the DRT.
17, ma'am.
Yes.
My lord, but this writ is
Section
filed
70.
as to check on the very sanction of the
Hello.
loan, my lord.
Surface
How can you raise all this dispute here, sir?
My lord, section 34 of the surface bars me from seeking any relief before the civil court, my lord.
No, no.
In spite of that, she filed the civil suit, my lord.
My lord, I
Suit
have
for
filed a
partition,
suit
she
for
has filed
partition,
before
my
the
lord.
civil court.
Any person,
including the.
any person including borrower.
My lord, my lord, the first mortgage is not yet discharged. Even when the first mortgage is pending, the two mortgages are executed by my mother, not by me, my lord. Where after my father's death, I get an equal share in the father's property because he died interstate, my lord. My lord, my sincere submission, my lord.
Learned counsel for.
My lord, my sincere submission on the two mortgages, my lord.
The fourth respondent, bank, submits that the petitioner.
My lord, one
not
last
being
submission, my
a
lord.
borrower or a person who has mortgaged the property in question
My lord, one submission.
to the bank is before this court questioning the possession notice,
H2 and H3
questioning the notices issued
under section 13.
under section 13 bracket 4
of the
dated
surface.
8/11/2024.
My lord, one submission, my lord.
Comma, when admittedly the bank has proceeded to take action for recovering the outstanding loan amount along with the accrued interest
More than
against
4 crores.
Huh?
More than 4 crores, my lord, as on today.
My
the
lord, I can,
partners and joint borrowers, namely respondents number 1 to 3 herein.
Please.
my lord, not 1 to 3, my lord. 1 to 3 are not the borrowers at all, my lord. It is 4, 5 and 5, 6 and 7, my lord.
5, 6 and 7.
My lord, respondent number 1, 2 and 3 are the family members, my lord. It is only my mother who has
Learned
executed.
counsel submits that the outstanding loan amount is more than rupees 4 crores.
Please, ma'am.
My lord, the first mortgage, the outstanding is only 12 lakhs, my lord.
And section 17 of the Surrogacy Act 2002 clearly provides that any person, bracketally including borrower, aggrieved of any of the measures referred to in subsection 4 of section 13 taken by the secured creditor is required to make an application before the debts recovery tribunal having jurisdiction in the matter, and therefore this writ petition is not maintained.
Please.
My lord, until such time till I file.
Which are that judgments? Do you have it here? The one that we were seeing yesterday, Matthew. In the case of authorized officer, State Bank of Travancore, and another versus Matthew Casey, bracket 2018, 3 SCC, page 85. The Honorable Supreme Court has held that the High Court, without considering the objects and reasons behind enactment of Surrogacy Act, and without noticing and discussing the well-settled law laid down by the Honorable Supreme Court on interference in writ jurisdiction, where alternative statutory remedies are available to aggrieved, granting ex parte interim relief on no special reasons, held that such approach of the High Court was not proper, and therefore could not be approved. Full stop. Next para. Having regard to the settled position of law, that even a person who is not a borrower, seeks to raise a challenge to the measures taken by a secured creditor to recover the outstanding debt, is required to approach the debts recovery tribunal alone. Full stop. In the circumstances, such writ petition cannot be entertained. Full stop. Next para. Accordingly, the writ petition stands dismissed.
Sachin BS, writing bill number 33.
I appear for the petitioner, my lords.
Yes.
Petitioner's vehicle was repossessed, my lords, without following Surrogacy Act, without following any guidelines, my lords. Petitioner's vehicle, my lords, which was containing aluminous nitrate, my lords, which was fully loaded. It has been repossessed, my lords, without following RBI guidelines, without following our Surrogacy Act, without 13.2 notice or 13.4 notice. There has been given a demand notice, my lords, where they say, as in where in condition ಅಲ್ಲಿ 7 ದಿವಸದಲ್ಲಿ ನೀವು ತುಂಬಲಿಲ್ಲ ಅಂದ್ರೆ we'll sell off the property, sell off the vehicle ಅಂತ. 60 days prior, they have to give me 13.2 notice under Surrogacy.
Who appears for Reserve Bank of India? Issue notice to response number 1 and 2.
Notice ಆಗಿದೆ last time. Notice ಆಗಿದೆ. 1, 2, 3, 3 ಜನಕ್ಕೂ notice ಆಗಿದೆ. There is an interim order, my lords, not to precipitate.
List this matter after service of notice on the respondents.
My lords, I may be permitted to take hand summons, my lords, against respondent number 1 and 2.
ಅಲ್ಲ ಆಗಲೇ ಹೋಗಿದೆ ನೋಟಿಸ್.
ಅಲ್ಲ.
You are only awaiting.
Yes, my lords, ಅದಕ್ಕೆ ಅವರು
ಆಗಲೇ ಹೋಗಿದೆ ರೀ ನೋಟಿಸ್. Let it come.
My lords, short date may be fixed, my lords. If on that day, if they not come, then I'll, because ಅದರಲ್ಲಿ vehicle ಅಲ್ಲಿ
The interim directions given earlier stand extended till the next date.
My lords, in my vehicle there is a load, my lords, of aluminous nitride which is combustible. ಈಗ ಅದನ್ನ ಅಟ್ಲೀಸ್ಟ್ ಅದನ್ನಾದ್ರೂ that doesn't belong to the bank, ಅದನ್ನಾದ್ರೂ ರಿಲೀಸ್ ಮಾಡಕ್ಕೆ ಕೊಟ್ರೆ ನನಗೆ ಆಗುತ್ತೆ ಅಂತ. Because till they appear and then all this happens, my lords, then ಅದರದ್ದು porosity.
Ask for hand summons that time itself.
My lords,
ಈಗಾಗಲೇ ನೋಟಿಸ್ ಹೋಗಾಗಿದೆ ಕಣ್ರಿ.
ಅಲ್ಲ ಅಟ್ಲೀಸ್ಟ್ ಅದ್ರಲ್ಲಿ ಹೌದು ಅವ್ರಿಗೆ
use now.
ಅದ್ರಲ್ಲಿ
unless the other side appears, how can I pass this order?
At least consignee ಅವ್ರದ್ದು goods ಹೋಗಾದ್ರೂ ಹೋಗುತ್ತೆ. Otherwise that porosity of the good will go.
Submission should have been made when the matter came up for preliminary hearing.
My lords, pardon me, that day I was
What can I do?
My lords,
release this matter. ಅದು list this matter ಅಂತ ಹೇಳಿದ್ದು ತೆಗೆದ್ಬಿಟ್ಟು release this matter on 15th of January.
Yes, my lords.
Yes. Interim order granted earlier stands extended in the next date hearing.
Obliged.
Yes.
34. Amarnathan.
Respondent, my lord.
Feeling the sport directed the bank to give information regarding the auction of the principal borrower's property yesterday, my lord. They have to provide
Furnishing the details, my lord.
Copy
Sections.
Huh?
Furnishing the details of the successful bid.
Copies, sir.
The lender is challenging the sale notice under Surface Act, my lord. They have an alternative remedy.
Principal
Only grievance is
borrower
that,
property more than 8
guarantor-
crores idru sah ನಂದು for 55 lakhs ಇರೋ guarantor property auction ಮಾಡಿದ್ದಾರೆ, sale not to confirm ಮಾಡಿದ್ದಾರೆ. ಇದ್ರ ಬಗ್ಗೆ I make some submissions tomorrow, my lord.
This is a third round of litigation, my lord. The only grievance is that he is a director and he has resigned from the director and he is not liable. That is the contention. And
He
he's a-
resigned from
since
the
he's a
company
guarantor,
22
his
Mela, that was
liability is
informed
purged.
to the registrar of companies. Companies have accepted. The bank was informed that he has resigned. Still then Mela, they sell the guarantor's property, principal borrower property. Yesterday there was an auction. I don't know what has happened yesterday.
Auction has not taken place, my lord. It's a collusive litigation.
Collusion is you.
And it has been encumbered. The reason commercial OS also has been filed by the agreement holder. Agreement holder, subsequent to mortgage, agreement holder has filed the thing, my lord, and suit for specific performance of contract.
That is pending. It's a collusive litigation and they have not taken steps till now in all the three petitions. For respondent number 2 to 6 are the, respondent number 2 is the borrower and respondent number 3 to 6 are
notice.
the guarantors, my lord. And the
Guarantors.
guarantee is not disputed.
Principal borrower ಮೇಲೆ ಇದೆ.
And
ಏನಾಗಿದೆ
34.1
2009 company ಸುಡುವಾಗ I had only 3% share in the company. I was a director. 22 ನಲ್ಲಿ I resigned and the registrar of companies accepted my resignation. That was informed to the bank also. Thereafter the principal borrower bank transactions ಇತ್ತು. ಸಡನ್ ಆಗಿ ನಂದು ಒಂದು 50 ಲಕ್ಷ ರೂಪಾಯಿದು ಒಂದು ಸೈಟ್ ಇತ್ತು, ಅದನ್ನ ಮಾರ್ಗೇಜ್ ಮಾಡಿ ಅದನ್ನ ಫಸ್ಟ್ ಸೇಲ್ ಮಾಡ್ತಾರೆ. Principal borrower 8 ಕೋಟಿ ಪ್ರಾಪರ್ಟಿ ಇದೆ.
When you went out of the company, you did not take back your property?
No, 22 ಇಂದ ನಾನು ಟ್ರೈ ಮಾಡ್ತಾ ಇದ್ದೀನಿ. 22 resigned, accepted by resignation by the registered companies. ಹರಾಸ್ಮೆಂಟ್ ನಡೀತೇನೆ ಇತ್ತು. ಇನ್ ದಿ ಮೀನ್ ಟೈಮ್ ಇರೋಣ ನಂದೇನಿಲ್ಲ ಸ್ವಾಮಿ, ಪ್ರಿನ್ಸಿಪಾಲ್ ಬರೋದು ಆಕ್ಷನ್ ನಿನ್ನೆ ಮಾಡಿದ್ದಾರೆ 8 ಕೋಟಿ ಪ್ರಾಪರ್ಟಿ. ದಿಸ್ ಥಿಂಗ್ ಇಸ್ ಓನ್ಲಿ 3 crores. ಇನ್ನು 3 ಕೋಟಿ ಅದ್ರಲ್ಲಿ ಬಂತು ಅಂದ್ರೆ ನನ್ನ ಪ್ರಾಪರ್ಟಿ ಕಮ್ ಬ್ಯಾಕ್. ಇಟ್ ವಿಲ್ ನಾಟ್ ಟು ಕನ್ಫರ್ಮ್ ದಿ ಸೇಲ್ ಅಂತ ಅಷ್ಟೇ ಮಾಡಿದ್ದಾರೆ, ಆಕ್ಷನ್ ಮಾಡಿದ್ದಾರೆ.
ಇಲ್ಲ ನಿನ್ನೆ ಆಕ್ಷನ್ ಆಗಲಿಲ್ಲ.
ನಿನ್ನೆ
with respect to scheduled property auction has been taken place.
As per direction they are given
And so for a principal borrower's property auction has not taken place.
ಕೊಟ್ಟಿದ್ದಾರೆ. I'll verify it and tomorrow or day after my last
In itself is not maintained. This is the third round of litigation, my lord.
verify man.
The same, whatever I dictated now.
ಅಲ್ಲ
this matter.
ಅಲ್ಲ ಅದಕ್ಕೂ ಹೇಳ್ತೀನಿ ಸರ್, ಅದಕ್ಕೂ ಹೇಳ್ತೀನಿ ಅದಕ್ಕೂ ಹೇಳ್ತೀನಿ ಸರ್. ಅಲ್ಲ DRT ನೀವು ಯಾತಕ್ಕೆ ಹೋಗಿ ಬರಲ್ಲ ಕಾಕಲ್ಲ ಹೇಳ್ತೀನಿ. ಯಾಕಂದ್ರೆ 4 ಕೋಟಿ ಚಿಲ್ಲರೆ ಕೇಳ್ತಾ ಇದ್ದಾರೆ. ನಂದು ಪ್ರಾಪರ್ಟಿ 55 lakhs. ಸೊ ಅಲ್ಲಿ ಕೋರ್ಟ್ ಫೀ ಕೊಟ್ಟು 25% ಡೆಪಾಸಿಟ್ 1 ಕೋಟಿ ಚಿಲ್ಲರೆ ಡೆಪಾಸಿಟ್ ಮಾಡಬೇಕು. ಮೈ ಪ್ರಾಪರ್ಟೀಸ್ ಓನ್ಲಿ 50 lakhs. ಅದೆಲ್ಲ ಹೇಳಿದ್ಮೇಲೆ ಸಹ ಇಲ್ಲಿ ಎಂಟರ್ಟೈನ್ ಮಾಡಿ ಸರ್. ಯಾಕಂದ್ರೆ ಮೈ ಪ್ರಾಪರ್ಟಿ 55 lakhs ಅಲ್ಲಿ 1 ಕೋಟಿ ಅಲ್ಲಿ ಡೆಪಾಸಿಟ್ ಮಾಡಬೇಕು.
ಸರ್ಫೇಸ್ ಯಾಕೆ ಕೊಡ್ರಿ?
ಅಲ್ಲ ಗೊತ್ತು, ಐ ಆಮ್ ಅವೇರ್ ಆಫ್ ದಟ್ ಮೆನ್. ಐ ಆಮ್ ಅವೇರ್ ಆಫ್ ದಿ ಜಜ್ಮೆಂಟ್ ಆಲ್ಸೋ.
When notice was issued under section 13(2),
yes ma'am,
what did you do?
Principal borrower paid 84 lakhs. 4 ಕೋಟಿ ಚಿಲ್ಲರೆ ಕೇಳಿದಾಗ
It was under mortgage?
ಎಸ್ ನಾವು ಹೇಳಿದೀನಿ ಸರ್, ಮೈ ಪ್ರಾಪರ್ಟಿ 55 lakhs. ಪ್ರಿನ್ಸಿಪಲ್ ಬಾರೋವರ್ 84 ಲಕ್ಷ ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ. ಕೊಟ್ಟ ಮೇಲೆ ಮತ್ತೆ ನಂದು ಪ್ರಾಪರ್ಟಿ ಫಸ್ಟ್ ಆಕ್ಷನ್ ಮಾಡಿದ್ದಾರೆ. ಅವ್ರ ಪ್ರಾಪರ್ಟಿ
Notice was not issued to you?
It was issued.
Then what?
Then I replied stating that I have already resigned from the company. ಅವ್ರ ಪ್ರಿನ್ಸಿಪಲ್ ಬಾರೋ ಪ್ರಾಪರ್ಟಿ ಇದೆ ಅಂತ ಹೇಳಿದಾಗ ಅವ್ರು ಮಾಡ್ತಾ ಇದ್ರು. ಆಕ್ಷನ್ ಬಂದಾಗ ನಾನು ಐ ಕಮ್ ಬಿಫೋರ್ ದಿಸ್ ಕೋರ್ಟ್ ಸ್ಟೇಟಿಂಗ್ ದಟ್ ಆಲ್ರೆಡಿ ರಿಸೈನ್ ಫ್ರಮ್ ದಿ ಕಂಪ್ನಿ. ನಂದು ಆಕ್ಷನ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ಅಲ್ಲ ಐ ಮೇಕ್ ಮಿ ಸಬ್ಮಿಟ್. there are 2 submissions, but there are 2 citations. One division bench of this court ಒಂದು ಜಜ್ಮೆಂಟ್ ಇದೆ, ಒಂದು NCLT ಒಂದು ಗ್ಯಾರಂಟರ್ ಪ್ರಾಪರ್ಟಿ ಯಾವ ಮಾಡಬೇಕು ಅಂತ ಒಂದು ಜಜ್ಮೆಂಟ್ ಇದೆ. I'll argue on that basis ಮೇಲೆ getting the information of this yesterday's auction ಮೇಲೆ ನಾಳೆ ಹಾಕೊಂಡು ನಾನು ಆರ್ಗ್ಯೂ ಮಾಡ್ತೇನೆ. ನಾಳೆ ಅಥವಾ ನಾಡಿದ್ದ. I just wanted the information of yesterday's auction.
Yesterday's auction has not taken place with respect to principal borrower's property, my lord.
ಅಲ್ಲ ಅವ್ರದ್ದು
For want of bidders and there is an encumbrance also on that.
55 ಲಕ್ಷದ ಪ್ರಾಪರ್ಟಿ ಮಾಡಿದ್ದೆ. ಆಕ್ಷನ್ ಆಗೋಗಿದೆ ಸರ್, ನಾಟ್ ಟು ಕನ್ಫರ್ಮ್ ಅಂತ ಅಷ್ಟೇ ಆಗಿದೆ. ಅದು ಐ ವಿಲ್ ಗೆಟ್ ಇನ್ಫಾರ್ಮೇಶನ್ ಹೌ ಇಟ್ ಇಸ್ ನಾಟ್ ಆಕ್ಷನ್ ಅಂತ. ಯಾಕಂದ್ರೆ ನನ್ನ 5 ಜನ ಬಿಡ್ಡರ್ಸ್ ಇದ್ರು. ಇವ್ರು ಏನ್ ಮಾಡ್ತಾರೆ ಅಂದ್ರೆ ಆಸಿಸ್ ಬೇಡ ಅಂದ್ಬಿಟ್ಟು ಮೆಷಿನರೀಸ್ ನಾವು ಕೊಡಲ್ಲ ಅಂತ ಕೂತ್ಕೊಂಡಿದ್ರೆ some bidders they are not action.
You made a submission which has been recorded that the property of the principal borrower has been ordered to be sold pursuant to the notice
No,
dated
not principal borrower, my lord.
2020.
Not with respect to scheduled property, that with respect to guarantor's property.
Then record ಮಾಡೋದು last time order.
ಅದು ಲಾಸ್ಟ್ ಟೈಮ್ ಆರ್ಡರ್ ಅಲ್ಲಿ ಸರ್.
ಇಲ್ಲ
ನೆನ್ನೆ ಆಕ್ಷನ್ ಇದೆ ಸರ್. ನೆನ್ನೆ ಆಕ್ಷನ್ ಮಾತಾಡಿಲ್ಲ.
This is the order that is recorded.
ಇದೆ ಸರ್, ಐ ಗಾಟ್ ದಿ ಆರ್ಡರ್.
That's
what
Learned counsel for respondent submits
they
that
were
the subsequent to auction conducted on 17/12 with respect to the scheduled property, my lord.
Order.
Learned counsel for the respondent bank submits that pursuant to auction conducted on 17/12/2024, the successful bidder had bid a sum of rupees 96,71,000 and successful bidder has paid EMD of 5,67,100 rupees. The respondent bank shall place on record details of successful bidder.
First sentence ಓದ್ರಿ ಕರೆಕ್ಟ್ ಆಗಿ.
ಅದೇ ಸ್ವಾಮಿ, ನಾನು ಅದು ಸಕ್ಸಸ್ ಆಗಿದೆ. ನೆಕ್ಸ್ಟ್ ಕಮಿಂಗ್ ಟು ದಟ್ ಥರ್ಡ್ para, the learned counsel for the petition submits that the property of the principal borrower has been ordered to be sold pursuant to the notice dated 21/12/2024 and reserve price of the said sale is a sum of rupees 5,48 lakhs. It is further submitted that the auction pursuant to the sale notice dated 21/12/2024 is scheduled to be held on 7/1/2025. That has not taken place, ma'am. It is not the subject matter of this writ petition. The subject matter of the writ petition is the property belonging to the guarantor, my lord. That has been taken place. That is what I made
What is
submission.
the outstanding loan amount?
4.58 lakh.
So that base price fixed at 5 crores and odd.
ಅದು ಸೇಲ್
In
ಆಗ್ಲಿಲ್ಲ.
respect of the property of the principal borrower.
Principal borrower.
That was required to be conducted today.
Yesterday, my lord.
Yesterday.
Yesterday. It was not taken place, my lord. ಅದು ಎನ್ಕಂಬರೆನ್ಸ್ ಆಗಿದೆ.
My lord, the
It's a
last sentence of
police
the-
litigation.
The respondent bank
ಅಲ್ಲಿ
shall
2 crore advance amount ಕೂಡ ತಗೊಂಡಿದ್ದಾರೆ. He has not paid. Hence the agreement holder has filed that suit, my lord.
And the last sentence of
Commercial
the
OS
respondent
number.
bank shall place on record the details of the auction conducted on 7/20/25 pursuant to the sale notice dated 21/12/25, wherein the property of the provincial borrower has been borrowed after sale. So ಇದು ನೆನ್ನೆದು ಈಗ ಕೊಡ್ತಾ ಇದ್ದ memo that I'll get instructions, I'll argue the matter tomorrow.
Yeah, I'm placing it on record, my lord.
ಅಲ್ಲ anyway, ಮೇಲೆ they
That has not taken place.
auction has
That
been
is not
taken
a
place,
subject matter of this repetition also.
only not to confirm on
What
the-
are you placing on record?
A memo I'm placing on record with respect to the auction with respect to the
Learned counsel for the respondent bank has filed a memo pursuant to the directions issued by this court on 30/12/2024. Stop. It is stated in the memo that the auction conducted on 17/12/2024 pursuant to the sale notice dated 29/11/2024. One Mr. Arun Kumar L, son of Lachma Nayak, he is the highest bidder for an amount of rupees 96,71,000. And he has paid. ಅದೆಲ್ರಿ ಅದಾಗ್ಲೇ ಹೇಳಿದಿರಲ್ರಿ. What is, you are required to say, state what happened to this
yesterday's.
Yesterday, ನಿನ್ನೆ ಆಗಿದೆ ಸ್ವಾಮಿ. That has not taken place. That may be taken on record, my lord. My submission may be recorded, my lord. That has not taken place for want of bidders.
This information is already recorded.
Already
here.
there, sir.
ಇದನ್ನು ಕೂಡ ಇನ್ಫಾರ್ಮೇಶನ್ ಫರ್ನಿಶ್ ಮಾಡಬೇಕು ಅಂತ ನನಗೆ ಡೈರೆಕ್ಷನ್ಸ್
ಇದೆ
ಇದೆ. ಅದಕ್ಕೋಸ್ಕರ ನಾನು ಫರ್ನಿಶ್ ಮಾಡಿ.
I will also get information
And,
yesterday's what has happened, and my last
The successful bidder has paid EMD amount of rupees 5,67,100 on 17/12/2024 and has paid the balance amount of rupees 18,50,650 on 18/12/2024. Full stop. Accordingly, the successful bidder has deposited 25% of the bid amount.
25%.
25%.
25%.
25%.
Full stop. Next para. Learned counsel would further submit that the auction scheduled to be held yesterday, that is 7/1/2025, in respect of the property belonging to the principal borrower, could not be held.
Yes, ma'am. For want of bidders.
For want of
Bidders.
bidders.
Well, I have instruction that
And also there is an encumbrance also.
Well, there are bidders, my lord.
ಇಲ್ಲ ಸ್ವಾಮಿ.
Machineries is said they are not allowing to take it. That's why bidder did not. There are bidders. They say as is where in the auction ಅಂತ ಹೇಳ್ಬಿಟ್ಟು machineries ಕೊಡಲ್ಲ ಅಂತ ಹೇಳ್ತಿದ್ದಾರೆ. Machineries worth around 40 lakhs rupees. ಅದಕ್ಕೆ
Same
place on
submission was
record what
made in earlier writ petitions also, my lord. 14.2.
Well, this information I got now and I'll get information from the client, my lord.
Bank submission
Tomorrow
also
I'll make my submission. There are two judgments, due judgment and NCLT Act.
Learned counsel for petitioner released this matter on 13th of January.
The interim order not to confirm the sale only. Not to confirm the sale ಇದೆ sir, interim order.
ನೋಡ್ರಿ ಕೊಡ್ರಿ ಇಲ್ಲಿ.
ಇದೆ ಸ್ವಾಮಿ.
ಎಲ್ಲಿದೆ?
ಇದೆ
ಇದೆ ಸ್ವಾಮಿ, ಇದೆ.
not to
Not
confirm
confirm
sale
ಅಂತ
ಇದೆ. ಇದೆ ಇದೆ.
ಕನ್ಫರ್ಮ್ ಅಂತ ಇದೆ. Second para ಇದೆ.
The interim directions issued earlier to the respondent bank shall continue till the next date of hearing.
Much. Pray for time. Pray for time. Communication gap between me and my colleague, so my kindly short date may be. Communication gap between me and my colleague, so is not complied. Short date may be given. Vacation, due to vacation.
Already, that order was passed on 1912.
Yes, ma'am.
While directing issuance of emergent notice to the respondents.
Yes, ma'am.
And you don't take steps.
Short date.
Why should we extend the order?
No, kindly. Tomorrow I will comply it, my lord. Due to communication gap, me and my colleague. So due to vacation is left, so that's why. Please, my lord.
And this order is passed without any conditions imposed on you.
Please.
Which normally we don't do.
My lord. I beg to pardon, my lord, please. Tomorrow I will comply it, my lord. Yesterday we get, my lord, please.
Although this court had directed issuance of emergent notice to the respondents, by order dated 19/12/2024, while directing the respondents not to take any precipitative action without passing an order under section 14 of the Surrogacy Act, steps have not been taken by the petitioners for service of notice on the respondents. Full stop. Next para. Learned Counsel, however, submits that steps will be taken by tomorrow.
Tomorrow, please.
Full stop. If steps are taken tomorrow, office is directed to immediately dispatch the notice to the respondents.
Please.
Yes.
36, Kiran N.
Petitioner in this case. The grievance of the petitioner is resolved, my lord. And the interim order passed by this Honorable Court is duly complied by the respondent police, my lord.
Please file a memo. Please file a memo.
File, man.
Put a paper, Learned Counsel for the petitioner submits that the petitioner is satisfied, petitioners are satisfied with the action taken by the respondent police pursuant to the interim directions issued by this court. Full stop. Learned Counsel would therefore file a memo seeking leave of this court to withdraw the writ petition as not pressed. Full stop. Next para. Accordingly, the writ petition stands disposed of as not pressed.
36. Kiran N.
36 already. 37 ivago. 37.
My lords, in seal number 37, I appear for respondent bank. My lords, on the last.
Petitioner in this case, my lords, placing memo, my lords, complying the order, partially complying the order, my lords. Pursuant to the previous order, my lords, this court has directed me to deposit 15 lakhs. With great difficulty, I have deposited 6 lakhs, my lord, with the respondent bank. I am begged to 4 weeks time, my lords, to deposit the remaining amount.
What is the outstanding loan amount?
My lords, outstanding loan amount, my lord, factual matrix is this. Petitioner has borrowed 12 lakh rupees as a housing loan, my lords, way back in 2007.
What is the outstanding loan amount, sir?
Outstanding loan amount, what they state in the notice is 1.34 crores, my lords, which they don't have any basis, my lords. Lord's, bank is none other than a tenant of a petitioner who has rented out the premises. Respondent bank is none other than the tenant of the petitioner herein. They are in the premises. It was an understanding that they will that 12 lakhs what is being borrowed as a housing loan way back in 2007 will be deducted with respect to rent is with respect to scheduled properties concerned. And that is also been deducted. And now just because when they subsequently when they have not failed to pay the rent, I approached the civil court for initiated civil remedy for recovery of rent. As a counterblast, they have initiated surfacing against me. That is the factual matrix. And there is no mention as to when this account became NPA. I borrowed only 12 lakh rupees. My lords, at page.
My lords, if I may submit. My lords, the loan was taken in the year 2007. The account became NPA in the year 2009. We were depositing the rent in the savings bank account of the petitioner. The petitioner withdrew all the rent, my lords. Therefore, we could not adjust it towards the loan. The petitioner was well aware of this fact. Only from 2024 April, we were able to adjust it because the account itself did not let him withdraw the amount. Now the outstanding is 1 crore 30 lakhs. The petitioner was directed to deposit 15 lakhs on the last date, which he has not complied, my lords. He has deposited only 6 lakhs. From 2009, he has not serviced his loan. However, he has withdrawn all the rents that were deposited by the bank. And the sale that has been challenged by the petitioner has also not taken place. Hence, the writ itself becomes infructuous.
When did you issue 13-2 notice?
My lords, 13-2 was issued on 23rd May 2024.
When you are saying the account became NPA in the year 2009.
Please, my lords.
How is it that you issued?
My lords, we have initiated actions under RDDB Act, my lords. Simultaneously, we initiated Surrogacy last year.
Initiated action?
Under the RDDB Act, my lords.
When?
My lords, that I'll verify and give the date, my lords. However, the writ also becomes infructuous because the sale that has been challenged has not taken place. Due to the interim order that was granted by this court. However, he has not complied the interim order as well.
My lords, I have proved my bona fides. I have arranged 6 lakhs and I have deposited with the bank. I'll pay the remaining amount within 4 weeks, my lords. And my lords,
what is this?
Copy also has not been served.
My lords, that is completely irregular. My lord, they themselves say it is NPA became in 2019. My lords, loan
not aware that you took a loan in the year 2007.
My lords, that's what I understand. My lords, they are my tenants. They would have deducted from my rent.
Have ensured that the amount is deposited in the loan account.
My lords, it's the farmer.
The allegation is that you have taken away all the amount that has been deposited.
Account is with the bank, and he's a farmer, my lords. And I've showed my bona fides. I will deposit the remaining amount also.
The writ petition is not maintainable. Go before the DRT.
No, DRT also. I have
not going to all these aspects. Not possible.
Not a blatant irregularity, my lords. That is why I'm before my lords. 2019, they admit that they have made an NPA, my lords. I'm showing my bona fides.
Taken under section 13(4). You have to approach the DRT only.
When I approach,
you cannot file a writ petition.
My lords, DRT, my lord, paying port fees itself will become recurrent, my lords. I'm a poor farmer, my lords. Great difficulty I have given, and they're none other than my tenants.
Anyway, you are not complied with the directions.
I will come. I have paid 6 lakhs, my lords. I have paid 6 lakhs.
What was the direction given, sir?
15 lakhs. My lords, adjusting, my lords, in this great difficulty, my lords. I will pay, my lords. Least, my lords. My lords, it will be great difficulty, my lords.
Learned counsel for the respondent bank submits that interim directions were given by this court on 19/12/2024. That the staying the impugned notice dated 3/12/2024, subject to the petitioner depositing a sum of rupees 15 lakhs on or before the next date of hearing. Full stop. However, the petitioner has not complied with the directions.
Lords,
therefore,
I have deposited 6 lakhs, Lord.
Interim directions issued by this court should not be extended.
Lords, I have proved my bona fides within 4 weeks. I will file,
the petitioner, however, submits that The petitioner has deposited a sum of rupees
6 lakhs.
6 lakhs.
Yes, my lords.
Full stop. Next para. It is the contention of the petitioner, and in terms of the impugned notices, the outstanding loan amount is more than 1.34 crores.
Which has no basis at all.
Full stop. Therefore, when the petitioner has not even complied with the directions of depositing rupees 15 lakhs,
have partially come.
no further indulgence can be shown by this court.
My lords, I have partially bowed down to this order and complied. Given some time, lords, I'll do the needful, my lords. Please, my lords.
Release this matter on 20th of January. Yes.
Obliged.
Interim protection, my lord. At least till then.
Yes.
Abhilash Raju.
My lords, the advocate with the petitioner may be directed to serve me a copy. My lords, I have not been served till today.
Learned counsel for petitioner is directed to serve a copy of the writ petition along with annexures from the learned counsel for respondent.
Grateful.
Lords, I'm for the petitioner. Lords, there are a few office objections that I need to comply with. I will attend to them within the next 2 days, my lords.
Yes.
My lords, there are a few office objections I need to comply with. I will do so within the next 2 days, my lords. I would request that the matter be taken up. Otherwise, in the last date of hearing, my lords, after hearing, there was an impleading application filed. And it was told that LOI has been issued to them. My lords, the letter of intent is subject to the outcome of this writ petition, and it is at that stage where the matter is.
Yes.
So I would request for some time for me to comply with the office objections. My lords may take up this matter.
It is an application for impleading by as per the
Anyway, the direction is that it will only be subject to the outcome of the writ petition. Nothing more.
In the meanwhile, my application for impleading may be allowed. I am the successful bidder. My IA 1 of 24 is my application for impleading. I'm the successful bidder in this thing. I don't think even my learned friend has any objection.
No, my lords, in fact, considering the letter of intent issued to them is subject matter of this writ petition, they are a necessary party, my lords. I have no objection for them to come on record.
1 of 2024. Filed by Messrs. Macabre, BK Private Limited, who is the successful bidder,
Yes.
Is allowed, please, while permitting implement of the applicant as a party respondent to the proceedings.
I'll file the amended.
Counsel for the petitioner is requested to amend the cost title and furnish amended cost title within a period of 1 week from today.
Yes, my lord. 17th,
Full
by
stop.
17th.
In the meanwhile, office objections shall also be complied with.
My lords, if any statement of objections is, if the other side intends to file, let them file it by the next date is my.
We'll file our objections. We'll file our objections. No. Who is appearing for the?
I think.
My lord, I appear for the
RHV.
tender
It
inviting
is for you
authority,
to
lord.
file.
Yes, ma'am. By request.
Not the successful bidder.
Yes. Request for 2 weeks.
Challenge is to your action.
Indeed, my lord. Indeed. A request for 2 weeks time, my lord. I have just received parawise comments.
2 weeks are granted at the request of learned counsel for respondent number 1.
Please.
To file statement of objections.
I'm grateful.
Yes.
Grateful.
39.
No dates. No.
My lords, I appear on behalf of the petitioner, my lords, in this matter.
Lordship, in this matter, I undertake to appear for Karnataka State Medical Supplies Corporation, Lordship. I've received the power today. I
Learned
pray for
counsel.
a short accommodation.
Srimati Sumana Balika
Please, Lordship.
undertakes to appear for
Karnataka State
Respondent number
Medical
3, my lord.
respondent number 3.
That's right. Obligement.
Lordship, there are 2 more writ petition, Lordship. On the
Office is directed to show the name of the learned counsel in the cause list.
Lordship, there are 2 more writ petition, Lordship, on the similar cause of action.
This matter along with
Writ petition number 10393 of 2024 and 34966 of 2020.
please write
My
it
lords,
and-
those writ petitions are not on the same subject matter, my lords. They're on different subject.
Okay, let it come up, we'll
Obliged,
see.
obliged, my lords.
Yes.
The slight, they pertain to entirely different subject matter, my lords.
Release these matters on 16th of January.
My lords.
Orders passed earlier stand extended in the next date of.
Much obliged.
Serial number 40. Kavita D.
Bank, they're not deposited as per this honorable court order, Your my lord. Sale also not taken place because of state demand.
On 30/12/2024, the following order was passed. Extract ಮಾಡ್ಕೊಂಡು. Next para, learned counsel for the respondent bank submits that the petitioner has not complied with the directions issued by this court. Full stop. Consequently, the writ petition stands dismissed.
Serial number 41. Mahesh, yes.
Petitioner, my lord. Passport has been rejected on the ground that criminal case is pending, my lord. Earlier, when 482 petition was pending, my lord, I was given 1 year validity passport, my lord. That is expired, so I'm seeking for further extension of passport, my lord. I had reapplied again. It has been rejected on the ground that criminal proceedings are pending. I had declared it in the application form, my lord. So last time, 1 year passport was
What
issued.
happened to the criminal petition?
My lord, 498A offense was quashed. So far as 323 and 504 was kept pending. Trial has begun, my lord. PW1 has been cross-examined partly. Now it is stated for further cross-examination, my lord. He is, my lord, 70 years old, my lord. His son stays abroad in the United States. For that reason, I'm seeking for a passport, my lord. So my prayer is to extend it for 10 years, my lord. If it is extended by 1 year, it will be more than sufficient. I would be obliged, my lord.
For 1 year, it may be, for 1 year, it may be extended. Your lordship may direct us, my lord, to extend it for 1 more year, my lord. Will it?
Learned counsel for the petitioner submits that although the prayer in the writ petition is to issue directions to the third respondent, regional passport officer, to consider the application filed by the petitioner for reissue of passport for a further period of 10 years. Nevertheless, it would suffice if the passport is reissued for a period of 1 year.
Please.
Full stop. Learned counsel submits that the petitioner is aged about 70 years.
Please.
And his son is residing in
USA.
United States of America. Full stop. Earlier too, when the petitioner had filed an application for issuance of passport, the same was rejected on the ground that criminal cases are pending against the petitioner.
Please.
Full stop. However, thereafter it was found that on the basis of a criminal petition filed by the petitioner under section 482 of the CRPC, the passport was issued for a period of
1 year.
1 year.
Please.
Yen passport?
Passport, my lord. I had filed an IA.
Short validity passport.
Short
It's
validity.
called as short validity passport.
A short validity passport was issued for a period of 1 year.
Please.
Full stop. Therefore, it is the submission of the learned counsel for petitioner that the passport may be reissued.
Please.
On the same grounds for a period of 1 year.
Please.
Full stop. Next para. Learned Deputy Solicitor General of India.
PST.
DSG
Please.
submits that if that is the contention of the petitioner, that the passport may be reissued for a short period of 1 year, comma, appropriate directions may be issued to the third respondent. Please stop. Next paragraph. Consequently, the writ petition stands disposed of with the direction to the third respondent, regional passport officer, comma, Bengaluru, to issue a short
Validity
passport for a period of 1 year in favor of the petitioner, please, having regard to the facts stated herein above. Please, full stop. Ordered accordingly.
Please, grateful.
Number 42.
Not praise time. Senior has got held up in one more court almost. So praise time for a week, my lords.
A week's time is granted.
Date may be specified. Date may be specified.
For what?
For preliminary.
Bandogi, the preliminary hearing agle answer. No interim orders have been passed. Again and again, it cannot be listed for preliminary hearing or complaints of office objections.
Serial number 43.
They appear for the petitioner's counsel, my lord. In this matter, the petitioner is a film producer. He borrowed 2 crores rupees from the respondent bank. And one Sydney actress had to pay him 1.5 crores rupees for a picture release, and her check bounced. Thereafterwards, he filed 138 proceedings against her.
There are 2 writ petitions.
Yes, my lord. One for section 14 and another for 13 for taking possession and the sale of the property. Now, my lord, he has paid now 2 crores rupees till now to the bank. In the meantime, my lord, after filing this case, he was not well and he was hospitalized at.
What happened to? Have you complied with the directions issued by?
No, my lord.
Not complied, my lords. I am appear for the respondent bank. WP number 29262 section 14 order challenge madidro. He did not complete it. Not even a single rupee is paid.
2 crores has been paid.
We have taken physical possession of the property. 2 crores was paid in 2021, my lords.
No, my lord. I'll submit, my lord.
Order clearly says
no,
that if you don't comply, the interim module automatically vacated, and the respondent bank is at liberty to proceed in accordance.
Position is also taken, my lords. Position ತಗೊಂಡಾಗಿದೆ. Position ತಗೊಂಡಾಗಿದೆ. ಆಗಿದೆ. Position ತಗೊಂಡಾಗಿದೆ.
I'll submit, my lord. Because this honorable court passed an order in the Sydney actress writ petition challenging the Lok Adalat award that she has to pay that money. 1 crore 50 lakhs rupees she has to pay. Court of Please. 1 crore 50 lakhs rupees she has to pay.
All these submissions cannot be made.
ಒಂದೇ ಹೇಳ್ತೀನಿ
It is an interim order. Interim relief was given to you.
No, my lord.
Subject to the condition that you
ಈ ಹಣ ಮತ್ತೆ ಅವ್ರದ್ದು ಇನ್ನೊಂದು ಪ್ರಾಪರ್ಟಿ ಮಾರಾಟ ಮಾಡಿ ಅವರು ಈ ಹಣನ ಕಟ್ಟಬೇಕು ಅಂತ ಹೇಳಿ ಪ್ಲಾನ್ ಮಾಡುವಾಗ gall bladder problem agi he was hospitalized for 1.5 months. Now he is paying that money completely. The bank is asking 4 crores rupees, wherein he has to pay.
They are asking you whether you have complied with the directions you should.
No, my lord, I was hospitalized. My only submission, my lord, my only submission, my lord.
Respondent bank.
My only submission.
The petitioner has not complied with the directions issued by this court on 5/11/2024, whereby interim relief was given to the petitioner, subject to the condition that the petitioner shall deposit 20% of the outstanding amount within a period of 4 weeks from the date of the order. Full stop. The learned counsel would further submit that the respondent bank has proceeded to take possession
No,
of
my lord,
the property in question.
respondent bank has taken possession of the property. They have locked the house. My only submission is let the matter go before mediation center. Our 4 ಕೋಟಿಲಿ ಇದ್ದಾರೆ, ನಾನು 2 ಕೋಟಿಲಿ ಇದ್ದೀನಿ. Mediation center settle ಆಗ್ಬಿಡುತ್ತೆ. I will be saving about 1.5 crores rupees. Very hard on money. ಅಲ್ಲ, refer ಮಾಡಿದ್ರೆ ಸಾಕು. ಅಲ್ಲ, my only submission is I may be given 1 week time, extension time.
matters arising out of the Surrogacy Act cannot be sent for mediation. It is not within the powers of the manager to concede before the mediation center. ಮಾಡಕ್ ಬರೋದಿಲ್ಲ.
Many matters have been sent where the board has
ಮಾಡಕ್ ಬರಲ್ಲ sir.
This is a cooperative
Sir, it is
society.
beyond the powers of the manager.
No,
He can
submission-
act only in accordance with law.
My lord, for compliance.
The one-time settlement scheme available,
Yes.
you can seek for one-time settlement. ಅದ್ಬಿಟ್ಟು he cannot come and concede. ಆಯ್ತು ನಾವು ಇಷ್ಟು ಒಪ್ಕೊಂತೀವಿ ಅವೆಲ್ಲ ಮಾಡಕ್ ಬರೋದಿಲ್ಲ.
ಅಲ್ಲ, my
possible.
submission is only this writ petition order ಆಗಿರೋ amount ಅವರಿಗೆ 2 weeks ಅಲ್ಲಿ ಸಿಗುತ್ತೆ. 2 weeks accommodation may be.
ಮಾಡಿ ಏನಾದ್ರು ಮಾಡಿ.
2 weeks time ಕೊಡಿ.
Anyway, they have already taken possession.
ಅಲ್ಲ, ಅವ್ರಿಗೆ ಬೀಗ ಹಾಕಿದೆ. 2 weeks time ಕೊಡಿ.
Yes.
Oblige.
Matter stands adjourned by 2 weeks.
Oblige.
Yes.
Oblige.
44.
My lord, I represent the petitioner in this matter, my lords.
My lords, I represent the respondent bank, my lords. The last occasion, this matter was directed to be listed along with 33927 of 24 today. However, the connected matter is not listed today, my lords.
My lords, the issue is this, my lords. Auction is dated on 14th of this month, my lords. The issue is this. At page number 26, for a moment, my lords, may kindly turn to page number 26.
Senate Counsel for the respondent bank submits that by order dated 31/12/2024, the registry was directed to list WP number 33927 of 2024 along with this matter today. Full stop. However, the said writ petition has not been listed along with this matter. Full stop. Next para. Release this matter on 15th of January
My lords,
along with
auction
WP
is dated
number
on 14th, my lords.
33927 of 2024.
My lords, auction is dated on 14th of the month, my lords.
Yes.
45. Sharad JM.
A week's time is granted to the petitioner for complaints of office objection.
Serial number 46.
For a petitioner, only on his objection is that, my lords, Annexure A, we have got downloaded from the bank website, and that is not signed by the manager. Annexure A, my lords.
Annexure A is a notice.
Yes, my lord. That is, my lords, we have downloaded from the
What do you
website.
mean you have downloaded?
From the.
You are a borrower.
Yes.
This notice is issued to you. How can you say you have downloaded it from
My
the
lords,
website?
we have produced, my lords, that copy. That is the only office objection. No, my lords, your lordship may kindly see.
If you are raising a challenge to an order or a notice, you are required to furnish the original.
Original, my lords, but this is, my lord.
ಅದು dispensation ಬರಲ್ಲ.
Dispensation. The only urgency is this, my lords. Earlier, my lords, we have approached this honorable court, and there is an order. Your lordship may kindly see. Annexure B. Annexure B, page 23. My lords, page 22, your lordship may kindly see. The petitioner challenges, may I read that particular portion? Page 22. Petitioner challenges the said sale notice issued under Rule 86 of the Rule 9 of Security Interest Enforcement Rules. This court wide order dated 26/10 granted interim order subject to petitioner depositing the amount enumerated therein. Learned counsel for the respondent bank submits the sale on the scheduled date did not take place and the petitioner has not complied with the interim order fully. According, the petition stands disposed of, reserving liberty to the petitioner to approach the respondent bank to close the loan account under one-time settlement scheme. If such a proposal is made, the respondent bank to consider same in accordance with law. My lords, this order, my lords, was uploaded on 31st of December, my lords. We got, my lords, copy on 31st December. Even on 30th, my lords, we approached the bank requesting for one-time settlement. They said they insisted for production of certified copy. On 31st, my lords, we got the copy at 11:55 a.m. There, my lords, we have sent the copy along with OTS application through WhatsApp and requested the bank for one-time settlement. In the meanwhile, my lords, they did not consider, and the same day, they held action at 5 p.m. My lords, in fact, as per the directions of this honorable court, my lords, we are, in fact, my lords, we have paid 59 lakh. We are ready to pay the remaining amount, my lords. We are not evading to pay the amount.
If you are ready, you should have paid it, sir.
My lords, what happened is now that action is held, and now they are, my lords, ready to insist the to issue for, this, my lords.
It is very
Sale
easy for you to
confirmation.
say, no, we are ready, everything is
No, my
ready.
lords, even.
ಯಾವಾಗ್ಲೂ ಹಿಂಗೆ ಹೇಳೋದು.
My lord, within 2 days, my lords, we will deposit the remaining
What
amount.
do you want now?
My lords, their, my lords,
Anyway, auction is
an humble
settled.
submission. My lords, action is held, they are now, they are, my lords, proceed to issue sale certificate. I am requesting only not to issue sale certificate. If 2 days time is granted, my lords, we will deposit the remaining amount and seek for one-time settlement. My lords,
Sale is already confirmed.
ಅದು amount final ಮಾಡಬೇಕು 50, we have deposited 59 lakhs. As per their loan account, my lords, we have to pay another 83 lakhs. So, my lords, that's why, my lords, we have offered, we have given one-time settlement application. My lords,
ಇವಾಗ ಎಲ್ರಿ ಬರುತ್ತೆ ಒನ್ ಟೈಮ್ ಸೆಟಲ್ಮೆಂಟ್.
ಅಲ್ಲ,
My lords, an humble submission, my
ಇಷ್ಟವನ್ನೆಲ್ಲ
lords.
ಕೊಡಕ್ ಬರೋದಿಲ್ಲ.
my lords.
See, it is a scheme that would be announced by the RBI. It is not available every time.
My lords,
Please understand.
An humble submission, my lords.
ನೀವು ಹೋದಾಗೆಲ್ಲ ನೀವು ಒಂದು ಅಪ್ಲಿಕೇಶನ್ ಕೊಟ್ರೆ ನಾವು ಕನ್ಸಿಡರ್ ಮಾಡಕ್ ಬರೋದಿಲ್ಲ. The scheme has to be announced by the RBI.
My lords, in November, OTS was being proposed, my lords. They haven't paid, my lords.
may I make a request?
November ಅಲ್ಲಿ OTS propose ಮಾಡಿದ್ವಿ, ಅವ್ರು pay ಮಾಡ್ಲಿಲ್ಲ ಸ್ವಾಮಿ. December 15th ಗೆ sale notice was being announced, my lord. Very next day they paid 5 lakh, my lords. No, they are very aware about the sale notice, my lords.
My lords, in fact, my lords, we have deposited some.
Sale is already
59
confirmed insofar
lakhs.
as item number 2 is concerned, my lords.
59 lakhs we have deposited. That is not in dispute. We have to pay another, my lords, remaining amount of almost 83 lakhs. We will, my lords, under one-time settlement, if they give some concession.
ಇವಾಗ ಮಾಡಕ್ ಬರೋದಿಲ್ಲ ಅವ್ರಿಗೆ.
ಅಲ್ಲ, as per the directions of this honorable court, my lords, they can consider.
No.
ಅಲ್ಲ, now, my lords, they are, my lord, the proceeding to issue sale certificate. No, my lords, if your lordship grants
When opportunity was given to you.
Definitely, my lords.
And an amount was arrived at, you did not pay.
No, amount
Now
was
you
not
are
arrived
saying,
at.
no,
It was arrived, my lords.
Amount was not arrived at. One-time settlement amount was not arrived at. As per, my lords, directions of this honorable court, we have approached the bank.
ಇದಲ್ರಿ ಅಕ್ಟೋಬರ್ ಅಲ್ಲಿ, that is what.
November,
he said.
November, my lords.
No one-time settlement was
November,
offered.
my lords.
ಇಲ್ಲ. My
That
lords,
was not complied with, my lords.
my lords,
Again,
what
my
he
lords,
is saying is the direction of this honorable court is not complete. That's what he is saying. No. In fact, my lords, we have deposited 59 lakhs.
ಅಲ್ಲಪ್ಪ.
OTS proposal was
Otilas
given, my lords.
That is
ಇಲ್ಲ.
what
It was given, my lords.
No, my lords, OTS was not offered. That is why, my lords, this honorable court made an observation to approach the bank seeking for one-time settlement. We were before the bank, my lords, on 31st. 30th ಹೋದ್ವಿ, ಅವತ್ತು ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ನಮ್ಗೆ ಸಿಕ್ಲಿಲ್ಲ. ಅದಕ್ಕೆ 31st ಸಿಕ್ಕಿದ್ದಕ್ಕೆ we sent it to
Council Street.
Prabhurao CB, my lords.
Prabhurao CB undertakes to appear for respondent number
Please,
1.
my lords.
Issue notice to respondent number 2.
my lords, till such
Learned counsel for petitioners is directed to serve copies of the writ petition along with annexures from the learned counsel for respondent number 1. Full stop. Next para. Release this matter on 15th of January 2025.
16.
Huh?
16.
13th or 16th. The first respondent bank is directed not to confirm the sale.
It's already confirmed, my lords.
No, my lords, not yet.
ಅಲ್ಲ,
Not to issue sale certificate.
31st.
Huh?
31st ಗೆ ಸೇಲ್ ಆಗಿತ್ತು ಸ್ವಾಮಿ, ಸೇಲ್ ಕನ್ಫರ್ಮ್ ಆಗಿದೆ, 25% ರಿಸೀವ್ ಮಾಡಿದ್ವಿ,
ಅಲ್ಲ,
ಕನ್ಫರ್ಮ್
sale
ಆಗಿದೆ.
not issue
We
sale
haven't issued sale
certificate.
certificate.
That item number 1 item.
Item number 2 ಆಗಿರೋದು ಸ್ವಾಮಿ, item number 1 ಆಗಿಲ್ಲ.
In
2 is
respect
already
of-
confirmed, my lords.
My lords,
2 is sold for 1 crore.
Sale has happened only in respect of item number
Item number 2, my lords.
What about item number 1?
No bidders, my lords. In so far as bidder ಇಲ್ಲ ಸ್ವಾಮಿ, item number 1 ಗೆ.
my lords, we are requesting only not to issue sale certificate, that's all. In respect of item number 2.
Are directed not to issue sale certificate
Respect of item number 2, my lords, we have stated in the schedule in the writ petition.
in respect of property number 2 as shown in the schedule
To the writ petition.
to the writ petition, comma till the next date of hearing.
Much of this.
Hearing interlocutory petition, serial number 47.
For the petitioner in this case.
Council responding number 3, Your Lordship.
As per the direction of this honorable court, 3 crores 95 lakhs has been paid, my lord. Extra 20 lakhs has also been paid. Filing a memo along with the payment.
Your Lordship,
Matter
I
have to be closed down, my lord. The matter can be disposed of. In the last occasion, we have filed a memo, my lord, along with the
payment schedule, which the bank has already agreed, my lord. Now we are ready to pay the amount, my lord. And this honorable court on the last date of occasion directed us to pay 4 crores rupees, which we have already paid.
Your Lordship, if you, I will just make Your Lordship a submission. We have entered into a settlement agreement, Your Lordship, which in the last set of hearing, they were directed to pay 3.98 lakhs. Even though the direction was given, they have paid. I'm not disputing that fact, Your Lordship. But the problem is that settlement agreement has been issued and then the repayment term has been issued. If Your Lordship can refer to the memo, which was filed by them on 20th/12, Your Lordship can refer to the memo. The repayment schedule has been made, Your Lordship, in page number 6.
Filed on 20th/12/2024.
2012. So this 3.98 crores is due from February 2024, Your Lordship. Combining from the outstanding from 31st August 2024, that comes for 3.98 crores. But Your Lordship, the EMIs which has been, that they were supposed to make a payment on October and September, they have failed to remit the same, Your Lordship. Lordship, for the same, I'm filing a memo today. I'm filing a memo with
that
the
extent,
email
my lord-
communication, which they have conveniently missed out to file it along with the memo in the last set of hearing, Your Lordship.
What happened? You undertook to pay rupees 3,95,000. 3 crores. 3 crores. You are paid.
In fact, not both the parties. Agreed. The entire for that. So 3 months. Filed a memo now saying the payment must be extended with 3 more months. That's the only. Then the court wanted to know what bona fide. My request was to the petition may be disposed of in accordance with the agreement the parties have entered into, except what of the friend, what we say. That is evidence very clearly.
Of December 2024. You are paid 3 crores 95 lakhs. What is the balance remaining?
Balance. It is 20th of December 2024.
Yes.
There is a particular schedule which is given. As per document number 2. The payment starts from what's the 29th February 2024. And ends on 31st August 2027. This is in the parties. But then starts to kindly peruse document number 1 at page number 4.
Yes, I am seeing it.
This is the what's the mail sent to us
by the respondent. Here, the reference. Document.
Yes.
With reference to the trail mail on the above section, we are happy to inform you the management accepted your proposal for repayment schedule. Hence, you are advised to remit different amount of Get that paid. Why? Our schedule ends of 30th April 2027. That's all. That is all. Not both the parties that have agreed. They are asked to pay 3/4.
As of December 31st, 2024, Your Lordship, they are due to pay 2.2 crores, which they have defaulted as per the settlement agreement as well. Now, Your Lordship, this matter is very insignificant. The reason why I'm saying that it is very insignificant is that, Your Lordship, if we can refer to the petition.
No, but if my learned friend wants to know, I have
Page number
serious
135, Your Lordship.
objection. My instructions are that the bank has agreed to that. If my learned friend has instructions that they are going to go back on this mail, let him say so, we'll argue on merits. But he must not act contrary to the instructions which we have in place. The mail says that they have agreed. The parties have come into some sort of an understanding. If my learned friend says that they are repudiating this email dated, which I have now brought to Lordship's notice, then the matter we may have to argue on merits. But we have in specific instruction, the bank has agreed. In fact, they told us to this extent, I must bring to Lordship's notice.
See, this is dated 20th of September 2024.
Correct, Lord.
This email.
Correct, Lord.
20th of September 2024.
That is true, Lord. That is true. Adar 3 months we could not pay. There was a difference of 3 months. Then what we moved this honorable court. Now, in fact, I have been told the bank, in fact, informed them, if kindly move the court, we will agree for that because it's question of 3 months difference between 3 months. Therefore, if my learned friend says that they are not in, they go back on this email, I'll argue on merits. If they are in agreement with the email, question of 3 months, the matter could be disposed.
Your Lordship, matter may be please be disposed of. I do not have any objection to the same. But any
disposed of?
They are withdrawing the matter, so matter can be disposed of. I'm sorry.
Barkale. Learned Senior Counsel Shri Prabhuling Navadgi, appearing for the petitioner, points out to the memo dated 20th of December 2024 filed before this court and submits that although the petitioners delayed the payments in terms of the agreed schedule by a period of 3 months. Nevertheless, on instructions, it is submitted that the respondent bank has agreed to reschedule the payment, extending the period by another 3 months.
Yes.
Full stop. Next para. Learned counsel for the respondent bank is requested to secure instructions in this regard and make submissions. Full stop. It would be better if instructions are received in writing.
Your Lordship, I'm filing a memo for the same. Memo will be taken on. I just
Saying what?
Your Lordship, the instruction has been given by the bank as well. I'll just
Saying
take
what?
Your Lordship. Saying that we are okay for the settlement agreement to be continued, Your Lordship.
Then what is the difficulty?
Therefore,
But just that, Your Lordship, they are not adhering to the settlement agreement repayment terms, Your Lordship. If Your Lordship can come to page number 7, Your Lordship. The bank has sent a mail to the council on the court. Thank you for sharing uploaded order so and so. Please refer to the attached schedule which was agreed by the company. Accordingly, petitioner company needs to pay up to date interest and installments. Company has paid interest till November 2024 on 26/12/2024, and interest for December 2024 on 30th/12/2024. Installments fallen due on 31st and 2024 and on 31st/12/2024. 2 months once bi-monthly, each total rupees 2.22.68 crores are still due as on date, your lordship, by 31st December.
Which one is it? Correct, sir. That is what they are saying. They have written to your bank saying the same can be extended by another 3 months. If you are willing to accept it, we can dispose of the writ petition.
Yes, your lordship. If the matter is being disposed of, I do not have any objections, your lordship.
No. Being disposed of, if you agree, all right, what was required to be paid by them?
Yes, as per this second installment.
As on 30th of April 2027,
The second installment.
according to what was agreed, the last installment was to be paid on 30th of April 2027.
Yes, sir.
Now they are saying the same will be paid.
Earlier 30th April, no, now 31st August.
ಅದೇ ಏಪ್ರಿಲ್ ಅಲ್ಲ ಏಪ್ರಿಲ್ 30th of
April
April
ಇತ್ತು.
2027. Now the last date of payment will be 31st of August 2027.
Please, your
If you agree with that, the matter can be disposed of.
Yes, your
It
lordship.
is only an extension by another 3 months.
Your lordship, I'll seek the instruction for this.
No, no, if they are agreeable, no, it could be disposed. I don't think.
October, December installment to be recovered.
They have gone personally, no, they have met them actually.
ಏನ್ ಹೇಳ್ದಮ್ಮ?
Your lordship, the bank is not willing to take that request from the petitioner's side.
Now when order is passed, please put it to your clients and take it in writing.
Your lordship. Sure.
All right. Release this matter on 15th of January.
Yes. Lordship may also record the payment which we have pursuant to the order passed.
No, they don't deny that one.
I'm not objecting.
Yes.
48. Say, Jayasima.
I appear for the respondent, my lord.
Yes.
In this case, my lord, I have filed an application for vacation of interim order. Status for past 5 months.
Honorable court said the matter has to be heard on the main matter, my lords, on the main petition.
This is the main matter only, my lord. The matter is very simple, my lord. Issue is very simple. Here, my lord, that in this case, my lord, that the borrower, that respondent number 4, the company, has borrowed money of about 4.5 crores, my lord. And then that amount was not paid and all, and it can't become NPA. And that bank filed an original application before the DRT. That DRT in 2007 passed an order.
You are appearing on whose behalf?
Pardon?
You are appearing for whom?
I'm appearing for the bank, IDBI Bank.
IDBA.
Yes, man. That OA was filed, original application filed by DRT, and DRT passed an order for 23 crores. That order is that there are two, the petitioners are guarantors. Borrower and guarantors, joint and severally, they have to pay this entire amount. That is in 2007. But 2006, my lord, that company, that respondent for, that winding up petition was filed before the company. That the official liquidator came to the picture and he took that all mortgage property along with other properties and all. And ultimately, after some time, he sold the property also. And bank received 8 crores, 15 lakhs from that official liquidator. And then they pursued this recovery from the various sources. And ultimately, on 9/7/21, that official liquidator return letter stating that this entire whatever source of recovery and all, it has been over. Now the company has been closed. So now this bank can take your own steps to recover the money. Then, my lord, because that decree was passed, then the recovery officer issued the demand notice to guarantors, stating that you have to pay so much of money. Against the demand notice, then they approached this honorable court. In fact, as per procedure, they should have approached DRT. DRT, they said, no, we will not approach because you are the guarantor, we will not pay that statutory deposit and all. Whatever may be the case, they approach this honorable court. This honorable court passed in status quo order, man. Now, that recovery officer, then this is that petitioner also submitted an application before recovery officer that no, you cannot pay because it is barred by time and all that. He submitted an application. Then he has given the detailed explanation as per page number 61 of the writ petition. There he says, no, it is the continuing process, because that matter was pending before company, company court, and they were recovering the money on behalf of the bank, and we received so much of money. Hence, that I have got the right to proceed.
What is the interim order issued by this court?
The interim order is to
Status quo
maintain the
order.
status quo, my lord. Because the detailed order is passed, my lord, saying that after a lapse of 15 years, my lord, after issuance of the recovery certificate, my lord, they have issued a demand notice, my lord. Till the 31/8/2007 is the recovery certificate, my lord. The demand notice was issued only in 2022, my lord. There's clearly the demand notice is clearly barred by limitation, my lord.
My lord, that when property is already taken by the official liquidator,
But
there is no
also, my
question
lord,
of that issuing the notice at that time.
And also what
But
has
now,
happened-
because now they recovered so much of money, and now they say 21.
So now trying to recover
From the guarantors.
Amount
From
under
the
which
guarantors.
provision?
Guarantors.
Under which provision?
No, that as per the decree passed by the debt recovery tribunal.
The same recovery certificate. my
Debt
lord.
recovery tribunal, that in OI they passed the decree against that borrower and the guarantors. So there is already a decree against the guarantors. Now we are that recovery officer is executing the decree. And that is permissible, my lord. Now that because that company court it was pending and they were recovering.
Matters to be decided on merits.
Please,
ಅಲ್ಲ ಮೆರಿಟ್ಸ್ ಅಲ್ಲ ಆದ್ರೆ ಒಂದು ಸ್ವಲ್ಪ ಅರ್ಜೆಂಟ್ ಆಗಿ ಮಾಡ್ಬೇಕು ಸ್ವಾಮಿ.
May make one
Posted for
submission.
Final hearing, my lord. It may be posted for final hearing.
That is required to be decided on merits.
Please.
And question of considering the application for vacating the interim order at this stage would not arise.
May make one submission in this.
Yes.
May make one submission in this case, my lord. If your lordship may kindly turn. If your lordship may kindly turn to page 27. I am on a very limited point, my lord. 27.
Appearing for whom?
I appear for the Union of
Central
India.
government.
I appear for the first respondent Union of India, my lord. The reason is this, my lord. Page 27. The prayer is sought against me to quash the section 21 and 30A of the recovery of debt to bank and financial institution as being ultra virus to the constitution. These two sections are sought to be unconstitutional. What is the prayer is sought for? The Rajasthan High Court, division bench of the Rajasthan High Court has already turned down the, upheld the constitutionality and turned down the prayer sought for. Therefore,
That portion of the prayer is already decided by
yes,
another
my lord,
court.
it's decided.
No need to consider.
Therefore,
it
my lord,
at this stage.
So my lord, this only thing is next week it may be posted, my lord, because the amount in order is
I am
huge.
not going to fix any date in these matters.
ಅಲ್ಲ ಒಂದು ಡೇಟ್
We'll
ಕೊಟ್ರೆ
see. Yes,
Interim order may be extended.
interim order granted earlier stands extended until further orders. Please.
Deeply obliged.
further order. Great.
ಅಡ್ವೊಕೇಟ್ ಕರ್ಕೊ ಬರಕ್ಕೆ ಸರ್ 49 ಏನಾದ್ರು ಡೇಟ್ ಕೊಡ್ತೀರಾ? ಎಕ್ಸ್ಟೆನ್ಷನ್ ಎಲ್ಲ ನೆಕ್ಸ್ಟ್ ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಲ್ವಾ?
ಯಾವ್ದು ಡೇಟ್ ಕೊಡಲ್ವಾ ಸರ್?
ಸರ್ 56 ಯಾವ್ದಾನ ಒಂದು ಡೇಟ್ ಕೊಡಿ 56.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಬರೀ ಡೇಟ್ ಮಾತ್ರ ಇದೆ ಸರ್. ನಾವು ಕೊಟ್ಟಿಲ್ಲ
ಎಲ್ಲ ರಿಪೀಟ್ ಆಗತ್ತಾ ನೆಕ್ಸ್ಟ್ ವೀಕ್?
ನಂಬರ್ 51 ಎಂಟ್ರಿ ಮಾಡ್ರಿ. ಎಲ್ಲ ಎಂಟ್ರಿ ಮಾಡೋರು ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ ಸರ್.
Serial number 52 tomorrow.
ಆಗತ್ತೆ ಸರ್. ಎಂಟ್ರಿ ಮಾಡೋರು ಎಕ್ಸ್ಟೆಂಡ್ ಎಲ್ಲ ಎಂಟ್ರಿ ಮಾಡೋರು ಎಕ್ಸ್ಟೆಂಡ್ ಆಗುತ್ತೆ ಸರ್.
Sir, serial number 51.
ನೆಕ್ಸ್ಟ್ ವೀಕ್
Court officer, serial number 75.
Serial number 51 ಡೇಟ್ ಕೊಡ್ತಾರೆ.
ಚೆನ್ನಪ್ಪ
ಡೇಟ್ ಏನು ನೋಡ್ರಿ.
ಚೆನ್ನಪ್ಪ
ಇವತ್ತು ಬಂದ್ರ
ಗೊತ್ತಪ್ಪ, ಹೋಗ್ಬಿಟ್ಟು ಬೆಂಚ್ ಹತ್ರ ಎಂಟ್ರಿ ಮಾಡಿದ್ರೆ ಒಂದ್ ಶಾರ್ಟ್ ಡೇಟ್ ಕೊಡಿ ಕೇಳು.
ಯಾವ್ದು ಡೇಟ್ ಕೊಡಲ್ಲ ಸರ್.
ಮತ್ತೆ
ಯಾವ ಡೇಟ್ ಮತ್ತೆ ರೀಚ್ ಆಗಿ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಆಗುತ್ತೆ.
ಎಲ್ಲಾರು ತಪ್ಕೊಂಡ್ ತಿರುಗ್ತಾವ್ರಲ್ಲ ಹತ್ರ ಹೋಗ್ಬಿಟ್ಟು. ಎಲ್ಲಾರು ತಪ್ಕೊಂತಾವ್ರಲ್ಲಪ್ಪ ಕೋರ್ಟಲ್ಲಿ.
ಬೆಂಚಲ್ಲಿ
ಆಯ್ತು, ಸರಿ 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 ಓಕೆ.
ಎಲ್ಲ ಶೀಟ್ ಇರೋದು ಬೇಕಾಗುತ್ತಾ? ಎಲ್ಲ ಶೀಟ್ ಕನ್ವರ್ಟೆಡ್ ಒಂದೇ ಇಲ್ಲ, ಮೊದಲೇ ಒಂದೇ ಇರೋದು, ಕನ್ವರ್ಟೆಡ್ ಇಲ್ಲ. ಆದ್ ಫಸ್ಟ್ ಇದೆ
Yeah, yeah. Took a long break.